comfortable if I was really as bad as they was making it. You know, nobody could be around me. So for me to be this calm, I must have some kind of inner peace. And my inner peace is knowing that once everybody take the time to really see what type of person I am, you'd be surprised that I stuck around this long. I have to make the life that I do live as happy as I can and try to do the best with what I have. You know, live the best life I can live, be as happy as I can be. Nothing is perfect for anybody. I don't know.
Boys, I swear, I think I figured it out. You know why they don't want us redneck brothers and sisters and the hood brothers and sisters getting along? You know why? Because we'd be unstoppable. I'm telling you right now, we would shut shit down.
Blessings. Guess who's back for another Court TV? Welcome to Uncensored Enlightenment Talk. Listen, guys, I am excited. I'm sorry I am late. I literally like watching what happened today on a YSL trial was literally like football to me. I was screaming. I was yelling. They came out with the play. Miss Ashley. Oh my God, we're going to talk about it today because if you don't know, I have been following the YSL trial. I haven't been reporting most recently, but I've been keeping my eye on it. Definitely keeping y'all up to date on what's going on with this crazy judge. Keep holding people in contempt. God, I want to tell you right now, I'm going to put this man on the screen. I'm going to start it off by saying this right now. I don't know what YSL did or what he did not do, but this lawyer right here, he is ride or die. If we talking about loyalty, holding up to your bar card, I have to give it to Mr. Steele as well as Miss Ashley coming out like a beast. Okay. Okay, let's get to it. So if you don't know, we're going to put the judge on the screen. Let me see if I got a picture of him. Let me see if I got a picture of the judge on the screen. Now, you know this judge right here. This judge has been very controversial. This is the Chief Judge Glenville, okay? So I'm going to give you a little background on Mr. Glenville, okay? Now, one of the things that I did find out, allegedly, is that he has post-traumatic stress disorder. Not making fun of that, but he does have one of those special dogs in the courtroom with him. And I will say that makes me understand why he behaves the way he do. We're going to highlight some some flashbacks of his behavior, him calling out other people, trying to, hold them in contempt. But let's get to know a little bit about Chief Judge Glenville. I do apologize. So he is from Columbus, Ohio. This gentleman was born in 1982. He attended the University of Georgia. Okay, he was in the Army Reserve Officer. He was Army Reserve Officer training in the Corps, program. That will say why this man has post-traumatic stress, allegedly. So this Chief Judge Grantsville has already received some criticism based on his denial of bond for Jeffrey Williams. Okay, that's where it really started, and his handling of the case. Okay, professionally known as Young Thug at the hearing in June 2022. Despite testimony in support of Williams, including from music executive Kevin Liles, a 15-year-old motivational speaker who created Williams with changing his life for the better, and several communities activists, Chief Judge Grantsville ultimately denied bond, keeping Williams incarcerated pending his trial. He stated that he was doing so based on the significant testimony and other evidence offered by prosecution showing that Williams was the leader of the YSL gang and that he represented a danger to the community, particularly to witness and other individuals. So this demonstrates the fine line that Chief Judge Grantsville must walk in this case. On one hand, he is doubtless aware of the injustice penetrated on the young Black man by law enforcement and the judicial system in Georgia, and of the bias held held against many Black hip hop artists. On the other hand, the charges are not baseless, and some significant evidence exists to support the accusation that Williams and other defendants committed at least one or some of the offense which they are charged. Okay, so that was a little snippet brought to you by the source. I want to source where excuse me. Well, I guess I was yelling. I'm sorry, y'all. I was yelling like a man. I was like, oh snap. I had to lean on the damn my bookshelf. I done passed out 2 damn times. So bear with me. We about to get to it. Now, we're going to talk a little bit about what happened today. Young thug lawyer held in contempt, taken into custody. Okay, according to the Atlanta Journal Constitution, let's pull this article and put it on the screen, and then we're gonna start showing some videos. Oh my God, I hurt my heart, and then put my man in jail. They put my man in jail. Did I put the wrong one up there? Pause. Hold on, sorry, I got other stuff that was not supposed to go up there. Hold on, I do apologize. You're not my own producer. All right, let's get on the screen. Get this article going. I'm not excited because I'm excited. The outcome of this is so dope. Like this is literally like a soap opera. All right, let's get to this article. Young thug lawyer held in contempt. This is brought to you by the Atlanta Journal Constitution. The judge presiding over the Young Thug lengthy racketeering case held the musician attorney in contempt on Monday after being confronted about a private conversation reportedly held between the judge, the prosecutor, and the state witness. So we're going to get into who I think this state witness is, and then we're going to flash back to another state witness. I think they were trying to avoid this guy from behaving like. Okay, because once somebody said a president is a rap. Now, there's been a lot of witnesses. I kind of talked about a few of them, but this one I'm gonna highlight. He was not playing. Okay, so Brian Steele was escorted out of the courtroom after refusing to tell the judge Glenville how he learned of the meeting, which he said occurred in the judge's chamber before court began Monday. You got some information you shouldn't have gotten. Look at this one. Look at him. Glenville said before, I'm sorry, I was screaming. I was yelling like a man. I couldn't believe it. I was like, this was football. I never got so excited. Because this man right here, he been stressing me out. That's why I stopped talking about this case, because the way he has been behaving, he's been so biased. He's been ridiculous. And I've been really feeling for the the defense, just as looking from a lawyer perspective, how hard it has to be in this situation with a judge like this, that's literally knocking down everything. Anything that you say, objection, overrule. And Miss Love, she's getting away with everything. So it really annoys me. But anyway, that's why I was so excited today. Like, oh, snap. Okay, so you're not supposed to have communicated with the witness who's been sworn, Still told the judge before asking for a mistrial. He was later allowed back into the courtroom. The witness, Keith Copeland, spent the weekend in jail after refusing to testify on Friday despite an immunity deal upon his testimony. Now, that's who I think they talked to. Copeland apparently had a change of heart on Monday and was brought to the witness stand wearing a blue gel jumpsuit. He dodged most of the prosecuted questions ahead of the lunch break, during which time Steele said he learned of the morning meeting. He was mad. He was mad. He's like, yo, you know what they did to me? I think that's what happened. And the jails talk, the streets talk. So it is what it is. Something happened, especially if he was locked up, a bird is going to go to Young Thug, and Young Thug can talk to his lawyer. That's how it goes. So we're going to talk about some of the things that the judge said and try to put on Steele to try to make it seem like Steele was doing something criminal. Whew, I was mad. But anyway, he said, announcing that he's not testifying, he'll sit for 2 years in supposedly this honorable court, or let me rephrase that. The court said, I can hold you until the end of this trial, still asked. All right, so let's get to it. This is the gentleman that we're going to highlight. I'm going to highlight another gentleman because this is the one I think that they had. I think this is the one they asked questions to. So now, what we're going to do is, before we get into what happened today, we're going to do a little flashback. Y'all know what I like to do. Let's flashback. I'm not going to flashback. I have a lot of videos that I have made on this, but I'm going to do a little flashback on some of the things that has been happening in the court. The judge, this is a clip that is brought to you by Channel 11 News. Let me get this off the screen. Let me get it up there correctly, babes. The judge is always getting upset. Okay, this is Judge Get Upset at Young Thug's lawyer. Now, we already know that it was a time where one of them was held in contempt or locked up in front of everybody at the beginning of the trial for allegedly bringing contraband in court. And that was proven to be shenanigans and a joke. We did a video on that. I'll put the link under there. If I didn't put it on YouTube, it's on Rumble. We talked about that, and I'm going to bring that gentleman on the screen, that the gentleman that they had held in contempt. And I love this lawyer too. I got to get his name before the end of the live. Remind me. This lawyer right here, he was held in contempt. Ride or die. Ride or die. If you ever want a lawyer, get a lawyer like this. Okay? Just warms my heart. Now, let's just play this clip at one instance where the judge gets upset at Young Thug's lawyer. And this is many instances, okay? And then I'm going to show you how he handles Miss Love when Miss Love misbehaves, because she misbehaves a lot. She's very disrespectful. Ooh, she makes me mad.
All right. Make an additional inquiry, please.
This is a 3-minute clip.
You can.
You mentioned earlier, asked me to prepare an order. Ostensibly, I presume this is denying the state's motion to remove Mr. Steele as attorney for Mr. Williams. Because there are 4 individuals who are mentioned in the reason for conflict, and we've addressed one of them.
Now, if y'all hear, y'all probably can't hear everything because it sounds a little muffled. They were trying to get Steele removed here right now. And this was about a year ago for a conflict of interest, because everybody wanted Steele as their lawyer, and they couldn't even get him removed then. But try to listen closely.
Address the second one, and the other one will not be addressed until at least the 8th. I would court for law. I'm drafting that order until we address all of those.
No. Go ahead and do the order for the ones that we have for today. I'll enter a supplemental order when those 2 folks are taken up, okay?
Yes, sir. May I say something else also, Judge?
You can.
Earlier, the court made reference to, I sort of asked some questions, some clarifying questions in regards to our manner of proceeding. And I think I take some exception to the court's belief, assertion at that point that, or attempt to dress me down.
I'm not trying to dress you. I'm not trying to dress you down. But this is okay. Since you brought it up, no, you may not at this point in time, because you interrupted me to begin with. Okay. We're here. Mr. Adams, here's the thing about it.
Oh boy.
You have to be patient with the court. You have to be patient with the court, because I got a lot of freight I'm trying to.
Now, wait, I just want y'all to listen. When the judge is tripping up and he know he did something wrong, this is how he talks. Like, wait. You know, it's about etiquette. It's about this, instead of addressing the actual issue. And this is exactly what he did today. He tried to supersede what Steele brought up today with a whole lot of fluffer. But let's listen. This is his same MO.
To manage. I'm always going to let you have and consider everything that you tell me and any motions that you file. Whatever. But what you do is, when you jump me, meaning that my procedure, or you jump in front of other people, then that it doesn't sit well. So I'm just going to tell you, if I offended you in any way, please take my apologies for it. It wasn't my intent to do so. I consider you to be a very fine attorney, and I've known you professionally for over 20 years. But having said that, I do get to control the method and manner of how things go in the courtroom.
I understand that. This is your courtroom, but I was asking a question to get some clarification, and I just feel like the court telling me to sit down, or what I can do is take my seat, was not appropriate. I treat the court always with deference, with respect. And the only thing that I ask Is that the court treat me the same way?
I'm required to do that, Mr. Adams. We both are under the rules of professional responsibility.
And what he's talking about now is the judge's etiquette, the mannerism he has towards the defense team. Is you sit down, you done, you sit down. Ms. Love, madam, anything else? Just let her keep going. We're going to show you a clip of him having an issue with his Miss Madam as well. So just listen, they have been addressing this judge about his mannerism, about the things he has been letting slip under the rug. You have had Miss Love say many derogatory things about the defense, about Mr. Steele. Mr. Steele has repeatedly put on the record, hey, she is defaming me. The thing she is saying is definitely like it's basically going towards my character as a lawyer. And I want to put it on the record that she is not supposed to say this. She is not supposed to say this. So hold on, let me move this clip. This is another clip. Hold on, let me move this clip. Now let's get into this. Young Thug judge threatened lawyers with 20 days in jail over punishment for contempt. Now this was 1 year ago. This is somebody else. This is his MO. He says it's about etiquette, it's about decor, and this is the way he tried to control the narrative of the court while letting, in my opinion, Miss Love and them run it. But today, I'm just going to say it, Miss Ashley wasn't playing. She was not playing. I'm already talking about, I was so excited. Let's watch this together. Young Thug judge threatened lawyer with 20 days in jail over punishment for contempt. This was a year ago. This is someone else.
How are we doing on that paper? I mean, are they?
And this is when he made them write a paper. I forgot what was the specific circumstances, but that was around the time where he helped the other gentleman in contempt, allegedly saying that he had drugs on him. The other drug. So it was a big spectacle at the beginning. Okay, and if you missed that, I'm gonna put the clips at the bottom of where we talked about this about a year ago.
The importance of professionalism. Yours is due by.
Look at my guy.
The 28th of April. I'm just checking. I'm just clocking. So we on track?
Haven't started.
Well, your better half said she's not writing it for you either. Okay, well, just want to let you know that. Okay, all right. So we're good. I'm sorry. Because that wasn't offered to you. You already asked me, could I pay the $1,000? I told you no. Well, I know you would, but that's not what's on the table.
So you said 28, right?
28, yes, at noon. Or you do 20 days.
Yeah.
It's 17-page paper on the importance of professionalism in the legal field and treating one's opponents with civility. Paper is to be published quality in APA format and at least 10 primary and 10 secondary sources.
Oh my God, did y'all hear this? Come on, if y'all never went to college, if y'all went to college, y'all be mad as hell. Do you know what he just said? Do the paper APA style, 10 references, and make sure that it's not only structured correctly, is that it's going to stay on the subject matter. And you can't have nobody else write it, or you're going to get 20 days in jail. This judge started off with the shenanigans. He started off on some nonsense, which was very unconventional. No one that I know of, and no one can state that a court case have went this wild ever in history. Let's continue to listen. You know how many times they have tried to call for a mistrial for this case? And the judge like, nope. I don't know how they're going to get it out this judge's hand.
Means that we should be able to send it to the to either the Georgia any one of the of our law, or actually law review, or any other place that accepts publications, and it should be acceptable.
I'm gonna stop right there. I just want to highlight that this behavior, it didn't just start here. He's been gunning after YSL lawyers for the whole trial. And I just want to remind you guys that when you're in court, the judge is not supposed to say things like, that's my prosecutor. You know, yeah, we had lunch last week. They're not supposed to be in cahoots with each other. The judge is supposed to be a non-party person, like a non-biased person, the judge, and it's supposed to be the prosecutor against the defense. Those two. But it don't seem to happen like that in the world that we call United States. Okay. I want to show you some of the corruption that happens out here in the ATL. You see what I'm talking about? We're going to get into the courts. These judges are so wrapped up in controlling the court that they're literally creating rules as they go. Allegedly. Now, let's see. Can we get to another clip? You should see my man's face. His face was confused. Like, hey, you want to put it back on the screen? Let me put him back on the screen one more time. Look at the lawyer. He like this. Let me just put this up here. I ain't never seen nothing like this a day in my life. You see this? I'm confused. He has the confused face on, and I am too. All right. Let me take him back off the screen, and we're going to get into our next clip. Outrageous young thug lawyer accused officials of planning courtroom chaos. Now, this was at the beginning of the trial. This is around the time where they felt like they set up the little drug bust when the guy had his prescription medications, and those prescription medications was less than the amount that he was prescribed, and it was no law that said that they could not bring medicine outside of the container into the courtroom, i.e., cocoa powder in the White House. Did y'all forget about that? Let me just throw that. You ought to throw a sidebar. Cocoa powder in the White House. So why wouldn't it be something inside the courts? But I'm not saying that lawyer did that, because he did not. Okay, let's get to this. This is brought to you by Law and Crime. This is a clip by Law and Crime. Young thug lawyer accused of officials of planning courtroom chaos. Don't do me like that. Hold on, guys. We want to shout out to Law and Crime. I watch you all the time.
Your Honor, I would just like to put on the record for today that I was asked to leave the courtroom, and I was instructed to leave all of my bags, computer behind. I have no way of knowing if my bag or my computer was searched. I don't know if any client confidences were leaked during that process. I have no idea what happened.
Captain Kendall, can you show Mr. Weinstein the video that we, on this particular proceedings when we were out of the courtroom?
Yes, Your Honor.
Okay, does that satisfy you?
Yes, Your Honor.
Okay, all right. Anything else?
That's all, Your Honor.
Okay, all right. Ladies and gentlemen, unless we have anything else, I'll go ahead and excuse for the evening. Okay? Huh?
Yeah.
You may.
I love Still. I'm going to tell y'all, I love this guy. I love this man right here.
Your Honor, I don't know if the record properly depicts what occurred, but
We don't know what occurred. You're going to need to file a motion.
I'd like to put this, though, Your Honor.
Oh, my God. Look, wait, I just got to say this. Do you see the reserve that Still has to have all this time, knowing that the judge is just throwing out outlandish things, cutting them off, being disrespectful? Watch his etiquette. That's why I admire this man. I want to be like Still in his spirit in the court, because this is how it's supposed to be.
Everybody stands when you come in courtroom or leave. We have respect for you. Mr. Williams is innocent. We came here to have a fair trial. And that's what you do. That's why we're going through this process that's taking months. And that's okay, because we're talking about something that could end people's lives. So it's worth it. I am not saying this is accurate, but I was told, and there's witnesses here, I was told that I could not call them, I don't know who they are, but that they were alerted to come to your honorable court today because there was going to be something newsworthy. This, the media was called allegedly by, now I'm not saying any of these prosecutors, but by somebody with their office. And if that really happened, that's outrageous. To be in the middle of a hearing.
That's why I'd like you to file a motion so that we don't further taint the proceedings, or I get a chance to kind of see what everybody's allegations are.
And that's, and I don't know if I could file it, but somebody can, because I didn't speak to those people. But Your Honor, that's exactly what we don't want to happen. You know, Mr. Williams doesn't want to start over. He doesn't want to do this again. He is struggling every day. He gets here, as the court knows, 4 o'clock, 5 o'clock in the morning,
Look, y'all. I'm sorry, I gotta highlight this. Look at Young Thug 1 year ago. And when y'all look at Young Thug now, a jail, that whatever that processed food is, he looking like a Teletubby. I was looking at Young Thug like, damn, you see how small he was? Watch when we look at the new clips.
He gets no
I
sleep.
know I've been watching this thing with a bird's eye. I'm like, look at my baby getting fat.
But we are fighting for his liberty. And Your Honor, if this was a orchestrated event, I feel like somebody needs to never do this again in any courtroom. And I know it was orchestrated because I know how Your Honor is. We've all do. We've been before each other a long time now. We were in the middle of a hearing, and to see one of our sheriff officials say, you know, get Mr. Ryan, it was clearly, because nobody would disturb your court. So it was clearly orchestrated with somebody. So my point is, Mr. Williams has done nothing, to my knowledge, to obstruct anything. I have begged this honorable court to consider bond, and I respect your ruling. But the truth of this matter is, today was outrageous, and it does hurt our system of justice. And I ask the court to never, ever allow, if it happened, a spokesperson.
Look at her head over there shaking. No, do not let him speak to you like that, Judge. Do not let him put that on the record. Yes, all of this is going to be on the appeal record, baby. This is how the lawyers are supposed to talk, to continue to put this on the record when they appeal. Go ahead and continue, Mr. Steele. Look at her bubble head over there. No, shut him up.
Person with the DA's office or anybody.
Look, about to pop
have some inside information and make this really a farce. This was an embarrassment. Thank you, sir.
And I said, if it's with anybody, if you feel that you need to put it in a motion for me to hear and consider, I would invite you to do so. So, and I can go ahead and take that up. Ms. Love?
No, we can't listen to Ms. Love right now because she gets me frustrated. But I just want to put my man Still on the stage to highlight what he has been going through. This was the chaos from the beginning. This is with the drug bust. Yeah, come on. His name was Mr. Ryan. This is who he's talking about. Mr. Ride or Die #1. Oh, let me put Mr. Ryan up here. One of my favorite lawyers. Respect to this man. I love him. I love anyone who is honorable and who's willing to stand up on their square, even though it's hard. He has to work with these people all the time. All of these lawyers and everything, they see each other all the time. They running cases through each other and everything. So this creates a hardship. Between them. Let's keep that in mind. All right, what else I got for you? Oh boy, Young Thug attorney accused judge of addressing him inappropriately in front of the jury. This was 2 months ago. Again, it's so much contention between the judge and Still. The judge been wanting Still off the case because, you know, Still can hold it down, and he don't like that. Oh, I'm so excited. This was like, ooh, they brought out the big dogs today. I mean, this case is directly connected to Fannie Willis, okay? And if I didn't tell y'all how allegedly it's connected to Fannie Willis in the background, we're going to maybe rehash that. I'm going to put the video under there because the streets talk in Atlanta. And it may be a reason why they're pursuing YSL. If y'all did not know, Miss Fannie Willis, before she was DA, represented YSL co-defendant. All right, and there's not gonna is Mano. Yep, I don't listen to that music, but I learned this. So she used to represent Mano. Mano did not get charged in this. Think about that. Something going on in the background. The block is hot out here. So let's play this. When I play the whole thing, and again, it's brought to you by Law and Crime. Young Thug attorney accused judge of addressing him inappropriately, just disrespectful.
That's about 20. In regards to what, sir? Oh, okay, what's your motion?
It's disrespectful. Oh, Mama, I miss this Still. Look at my guy. I love him. I'll be in the comments. Now go Still.
This is the second time that this honorable court in front of the jury has addressed me inappropriately and wrongly. Second time. The first time I gave the state discovery of a song from a Super Bowl. Weeks before, there was an objection. You assumed that I didn't give it to the state. I didn't want to embarrass the court. So you were yelling at me and saying, do you understand me? Do you understand me? And instead of saying, do you understand that you're wrong? I sat here and I said, yes, Your Honor. That was to protect the integrity of this courtroom and the court. Now you say in front of the jury how unprepared I am. I am not unprepared for anything.
Okay,
I have
Mr.
no.
Steele,
I need to make
Mr.
a
Steele,
record. Your Honor,
Mr. Steele, wait a second.
Record.
When you keep delaying, okay, and that's what's happening to the court. You keep delaying and elongating and pushing out these particular our ability to present a seamless case in front of the jury. That's my purview as a judge, and I've asked you a number of times, you and your colleagues on both sides.
And this is what he does. Mr. Still already explained, you made a mistake. I been gave that to them, but I just said that you was okay to save face, to say, okay, judge, because I didn't want to embarrass you. And instead of him listening that he was wrong, he go double down on, no, listen. And this is why I can't watch this man. Or this bubblehead right here. She makes me upset.
To go ahead and listen to whatever it is you need to do, prepare me as needed. Now, I asked you those two particular questions because if they turned over the audio to you in discovery and you've listened to them already, then you either have an objection or you don't have an objection. And I was trying to solicit from you whether or not we could just go ahead and just hear it. So you can imagine my frustration because all these little delays just elongate out our presentation in front of the jury. That's for your benefit, not for mine, Your Honor. So that's why I've told you all at various times during this particular case. It's not because I want to embarrass you, Mr. Steele. It's just that I'm trying to kind of keep this thing presented in a way that the jury can listen to it.
And the court is wrong. What happened was, let me finish, and I'm making this for the record. What happened is, and I don't get embarrassed by you, but I don't want to embarrass you. I made an objection that some of these jail calls have a third party who will not testify. I objected to hearsay. The state said it explains the effect.
Okay, which call?
You won't even
Which call? These calls, as you.
Okay, well then why aren't we taking them up beforehand?
The state just said just now, these are the 3 additional calls that they want to introduce.
All right. Well, then here's your response. I'm going to give you an acceptable response.
Well, I'm going to make my motion.
Huh?
I need to make my motion.
Judge, there's more to this than we need to.
He's not even letting Still talk. He's not letting Still make his motion. He's arguing back and forth with Still. The prosecutors don't even have to do much. The defense is literally going against the judge and the prosecutor. This is a hard case. And I'm telling you, disclosure is not that I believe that YSL is not guilty, whatever. I don't like injustice. And if he get railroaded, we get railroaded as the people. These cases get put into precedents and they use this against us. This whole proceeding is a clown show and out of pocket.
Listen to these calls.
Right.
Then I would have no, you didn't say that though. So I wouldn't have had that opportunity. But that's why I keep telling you this, okay? I mean, like I told you, forewarned judge, a happy judge. All right. So had you just told me up front, Judge, we have not had the opportunity to listen to all of those calls. We've only been able to listen to 2. I want to listen to the other ones. And
I've listened to the calls. I know. I don't know what the third one they're trying to do.
Okay, well,
listen, let me just finish. So you presuppose I don't know what the calls are. Well, I don't know what the third call is because Ms. Hilton, who's professional, said, I'll take a break and I'll let you know what it is. But the other 2 calls are the baseball game and at the chicken. They're discussing chicken wings. Or chicken. I understand those calls. There's issues in those calls that you need to address. But I politely make an objection and say, Your Honor, based upon what you told me, which is what you told me, we'll take it up later. I wanted to raise it. You tell in front of the jury how unprepared I am. And let me tell you something. I am not unprepared. I don't appreciate the court telling me that.
And you don't, and I asked you, tell the jurors that you
Okay.
were wrong when you admonished me last time. You said you wouldn't do that. This is the second time. And you know what it does to me? I don't care.
I'm upset.
I'm hurt because you're a court, but I really don't care. But what does it do to Mr. Williams?
Mr. Steele, I'm not trying to personally insult you or hurt your feelings, okay?
Forget
You
about
are a grown professional advocate. I am a grown professional jurist. And people say things to me that border on that.
All right, I'm gonna stop right here. So basically, what's going on here is that Mr. Steele made a motion to say basically these phone calls, I don't want them, coming in because the person who is the third party on this phone call that was recorded in jail is not going to testify. So that's hearsay. And instead of the judge trying to get to that, because the judge wants to allow the prosecution to put in everything allegedly, he's saying, oh, you're not prepared. You don't know what those calls are. You're trying to delay. He's not even letting Mr. Steele speak on his stance, causing this to happen. This is why I get frustrated with the judge, because his behavior is totally out of pocket. I'm going to say this. I appreciate the state of Georgia or the Senate actually having a committee to review the DA. I think they should have a committee to review judges and to review mayors based on all of the things that has been happening most recently. Mayors like Rogue Mayor Tiffany Henyard, DA like Rogue DA allegedly Fannie Willis. We have many judges that's in situations that are very out of pocket. Even that female judge who allegedly shot her ex in the head and then tried to convince him that he shot himself when he survived. And then her first boyfriend, husband, got killed the same way, and she beat those charges. Y'all know these things going on around here? I really do think we have to have more of a federal check and balance system of these judges that's put in place, because they are rogue. They are rogue. Let's just listen to a little bit more of Mr. Steele, because we're going to highlight Mr. Steele's fury, because they held my man in contempt for a couple of hours. We on live waiting for him to come back. And then you're going to talk about some, the outcome. Y'all know the outcome. I'm going to tell y'all. I was excited with the outcome, though.
Border on the lines of I could take action or not. You have certainly said some of those things to me during the trial of this case. I have let them go. So, sir, that's just the trial. That's just the trial of the case. Okay,
No,
but
that man's life is here.
and you're doing a fine job in representing him.
Well,
but you know what? That's just the way we are right now. But the crux of the issue is, Mr. Steele, and the representatives from the state and everybody else. What happens right now is I have to take a break in order to vet all of these issues, which I'm required to do, Mr. Steele. And that's what is kind of disappointing to me, because I have given you all this administrative time, all these breaks to go ahead and do this. And this is what delays the presentation of this case in front of the jury.
You know, if I would have done what the state did, and I'm not poking anything at Ms. Hilton, you would have said to me, why didn't you share those calls with him before? What, you were out all day today. We didn't start court till 1 o'clock. I would have shared them.
I know you would have.
But the state did.
So he's even highlighting that this is the state issue in this, even giving them the stuff late, because what he's trying to highlight is that still didn't listen to the third tape. You see what I'm saying? Whole bunch of nonsense. All right, let's move forward. I'm just showing you some of the things that Mr. Steele has been going through in court, the defense on the YSL trial, and it's been very trying. And I hope you guys understand how important this is, because if you're ever put on trial, you want to have a competent lawyer that's ready to defend you. Now I'm going to bring this. This is about 9 months ago. Young Thug legal team asked to remove co-defendant from trial. Okay. Now, ruling hold on. I think hold on. I think I was mixing that up. Hold on 1 second. That's like 9 months ago. Let's put this on the trial. Now, all right. There was a question of the judge. Judge denied Young Thug attorney to move to disqualify prosecutor. Now, that is around the time where I kept saying that Miss Love was being very disrespectful. She had did something out of good faith, allegedly, and he felt like it was intentionally done, and and she's literally throwing low blows at him. And this was the judge's response. Mr. Steele has been going through it with the judge as well as the prosecutor, Miss Love. Let's watch this little clip right here. And this is brought to you by Channel 11 Alive. Baby, look what they doing out here, running amok. Let's go, sir.
3.7. To the defense's arguments and assertion in the first grouping that has been brought to the court's attention on March the 28th and March the 29th of 2024, the court has heard some concerns from Mr. Steele saying that those conversations could not be challenged by any other examination than Ms. Love, and has thus asked the court to disqualify her. The court has considered that particular request, and in regards to the colloquy that is had between Ms. Love and Ms. Bennett, as referenced from the transcript, in the interest of fairness and judicial economy and clarity, the court will unseal the affidavit as it pertains to the material witness warrant that the state sought to comply with to facilitate Ms. Bennett's complying with being here as a witness. I will make that available immediately. I will do two things. I will sign an order unsealing that particular affidavit. I will also block out the proprietary information as it relates to Ms. Bennett from that. But Mr. Steele and Mr. Uhelski, I will make the balance of the affidavit in its entirety available, and I believe that will also provide you with information as to others that may satisfy your concerns and in respect to that issue.
I'm gonna stop right here. Now, this was another issue that Steele was having. Basically, the evidence that he was getting was partial or not full evidence, and then they keep on trying to put in recordings of third parties who are not coming in as witness and won't be witness. So they tried to allegedly hand him some type of affidavits that had partial information out. And I think what they would highlight is that these conversations that the prosecutors have with the witness, that they have to be disclosed. They have to be disclosed. And sometimes the way the conversation is had, in the same perspective, what we're going to talk about happened today, it makes the person listening a witness. So that's why he was asking to disqualify her on this point, because of whatever information or conversation she had was going to make her a witness, or she was going to have to disclose everything so they can all see what was said, or they're going to put her on the stand. This is what he's been going through. And the judge has been blocking a lot of what he's been trying to get through, and putting a lot of what I said Miss Love evidence through. Young Thug attorney absolutely loses it, screams at the judge and the prosecutor in the RICO trial. So now we kind of getting caught up on what's happening in the last couple of hours. Well, this one was actually 3 days ago. So 3 days ago, and this is what to you. Hold on one second. This is brought to you, another clip by Law and Order, okay? Young Thug attorney absolutely lose it, screams at judges and prosecutors in the RICO trial. Why? Why is he doing that? Don't put him out there like he's a madman. It's because he's defending his honor. He's defending his client through the shenanigans that's going on out here in Atlanta in these courts. It's crooked.
Sir.
You allow another moment when Miss Love calls me that I did not do something They have the exact image of what we got from the jail in Fayette County. That is it. And if I get another false allegation and you do nothing, I'm shocked. I'm appalled at you. I sit here day after day with this false allegation, just machine. I gave the state everything. There's been no disconstruction. There's been no purposeful. I don't care. I don't care. I give over everything. I've done this for 33 years. Never in my life have I seen a trial. I've done 300 appeals in the state of Georgia alone. I've never read a case like this. Judge, I gave them everything I had. I waited. I was at my office till 8, after 8 last night. I waited for their investigator to come by. I handed him an exact copy of thumb drive. They have everything that we got from the Fayette County Jail. There's been no deconstruction. There's been no purposeful exclusion. This is not the first time.
Okay.
And I apologize that I'm getting tempered, but I've never been treated like this. You talk about professionalism every week. Professionalism is lacking with one lawyer here. It has never been. I don't even like coming to court. I used to love this. I would die for what we do. I used to say, I'm dying. I would die. I couldn't choose a better profession. If I had litigated with Miss Love, I would.
Your Honor, could we strike the hominem?
No, we can't strike. If I have to litigate with this bubblehead, ridiculous lady, I want to quit my job. I never want to be a lawyer again. I can't stand her.
Really, could we strike that?
Okay, hey, everybody, calm down. Everybody, both of you, please be seated.
Judge, I'm not
Both of
done.
you, please be seated.
You have to
Why
do
you
something.
want to strike it from the record? Because you're disgusting, and this is how your colleagues feel about you. You're disgusting. I'm sorry, I'm upset. This is why I stopped watching it. This is why I watched it before I came on live, because I would have been yelling from the top of my lungs, like
Something. You have threatened me with contempt. You have threatened me with jail.
plenty of times.
If you go back in time, we can just start in voir dire. Jury after jury, you did individual voir dire painfully. Miss Love would come in and say that juror was crying. It was not true. You would say, that's not my recollection after I said it. You did nothing. We start the
But
case.
Mr. Steele.
I asked you, please.
Mr. Steele.
Please, Judge,
Mr.
how would you feel if
Let him
you were being
talk.
treated
Mr.
like
Steele.
this?
Mr.
Well, I'd
Steele.
like to finish.
Mr. Steele.
I gave them everything on that drive, and it's continual abuse of a prosecutor, of another member of the bar. I don't talk with Miss Love. And that's fine. I like that. But Judge,
He said, I like that because I can't even take her into court. I thank you. Please keep it like this.
I'm not going to stand here anymore. I don't care. You can take my bar card.
Mr. Steele, listen.
And Mr. Williams, to me, this is an innocent man. You talk about, Mr. Love said there's a man in the Fulton County Jail who shouldn't be there, Mr. Copeland. Mr. Williams shouldn't be in custody. But he's been charged, and we come here for a fair trial. It's been everything but that, according to Miss Love has tried to demonize me. At times, Mr. Adams. At times, Mr. Shaw.
I object to
Now
the ad
it's
hominem
Mr.
attacks, and I ask
All
for
because she wants to
Again,
win the
from the
case. And now she speaks over people. It's
All the
not
time.
right.
Look.
I
she
gave
stand
them
up,
every-
She stand up. She speaks over people, and you're gonna see how he handles it different today. The way he talks to them. Look at this broad.
Everything. And by the way,
Sit down.
what I want to tell you, by the way, it's not even the law.
She made me mad.
If they call that gentleman on direct, I don't have to give them anything before trial. I do it because you asked me to. You said, listen, we got a big case. It's going to take a long time. Give them things. I gave this, by this way, to the state October of 2023. October 2023, that was uploaded, given to the state. I hear about it now, and I wait there, and I give them the exact duplicate of what we have. And now there's a false allegation of misconduct.
but
And what I'm telling the court is what I said again. I do not appreciate it. And you have told it in front of the jury that I'm unprofessional. You were wrong. You based that on Miss Love's false representation.
Your Honor, again, the ad hominem attacks, Your Honor. I object, and he should stop.
No, he can talk about what has been happening to him. The ad hominem attacks. Yes, you lied. The judge followed, and then he discovered that you wasn't telling the truth. It's not an ad hominem attack. You're a damn liar. You be trying to slip things inside, and he always catches your ass. Go ahead, Mr. Steele. Keep doing your thing. This lady right here makes me mad.
Talking when I object.
Try to silence me.
Yeah.
Will not be silent.
Thank you. Who are you? Who are you? Who, because you object, you could just get up and start talking? I'm sorry, y'all. That's how I be. That's how I be. All right. Remember that you already reacted to this. So you're not reacting right now. We're talking with common sense. Okay, Grace? Don't be upset. Okay. I got a woosah. When I see this right here on the screen, she made me feel like Tiffany Henyard. I get mad. She's a disgrace to the bar. And I'm going to say that because she don't represent the people. She don't have the people best interests in mind. She's a great lawyer because she knows a lot of strategies. And when you have a alleged biased judge, it's going to work in your favor. But I'm going to shut up. Okay.
But Mr. Steele, here's the thing. Okay, I think that Mr. Steele, please be quiet at this point in time. You made your point. You made your point at this point in time. Both of you, please be seated.
Don't be over there praying over there. This one right here, I'm still trying to figure her out. Don't be praying. You working with the enemy and you learning her skills. This dark skinned one, I've been watching her and I listen to her. Her approach in court is much different than Miss Love, but she's still a little sharp. I'm watching her. But Miss Love have a mannerism and a disposition to her that is horrendous. It's something about her that disgusts me, that you just can't trust her, that she undermined, that she gonna always win her case no matter what she got to do. That's the type of thing that I get from her, Miss Love.
Sir,
Please be seated.
whatever you do is fine, but I care about Jeffrey Williams. It's the best.
Sir, it's obvious. I would expect no less because
Says the same thing. And as Mr. Still make his point, I would expect no less. Yes, you are supposed to represent your client, and that's what he has been doing. Go ahead, Mr. Still. Keep up the good work. Now we're gonna start to I think we're gonna get closer to what's happening today. Now, what's going on today? That was our flashback. Now let's get into the contentiousness that happened today. Young Thug attorney arrested in court, held in contempt. This is brought to you by Atlanta News First. We're gonna put that up there, and then we're going to get to it tonight. I want to say shout out to Rumble. Shout out to you guys. I see y'all. I appreciate y'all being here. Please hit the like button. Y'all know I've been watching this case, but I haven't made anything most recent. And this right here is for the streets. Okay, let's go. Hold on. Hear it. Oh man, this is the end result. Check out still. I'm gonna have to press mute and hit my clapping.
Your Honor, would the court afford me one moment to confer with counsel regarding the appropriate remedy in this type of
okay, all right.
I'm so proud of him. And who are you to talk about an appropriate remedy? To be the prosecutor. What are you talking about? But wait, this get better. Go ahead, Mr. Still.
May I say anything, Your Honor?
Yes, sir. You certainly may.
This is my God.
Mr. Williams does not wish to go forward without me being here. You are removing me against his will, my will. You're taking away his right to counsel. And you're conducting material parts of this trial without me present, and I can't learn about it by watching online. So for that reason, additionally, I asked for a mistrial. And I assume you denied, but I'd like you to deny our motions for mistrial. You denied the other people.
I denied your motion, but I'll certainly take that under advisement, sir.
All right.
We're going to be in recess for the next 5 minutes.
And that recess was like for 2 hours. Okay. We're in the chat waiting, like, what's going on? 2 hours. Where is Still? People in the comments like, free Still, free Mr. Still. So this right here, YSL trial witness become frustrated being questioned about 2000 13 interview. So that's just what happened. Now I'm gonna do one more flashback, and I'm gonna show you this gentleman. This is 11 Alive News, and I think what they were trying to avoid was what happened with this gentleman, because he came in there knowing how to do it. He came in there like, nah, I'm not about to put my family life in danger. I don't want to have no parts to this. This was years ago. Just listen, okay? Try to get yourself out of this thing. I'm telling you, can't be for the streets if you ain't ready to have to deal with this. This is a very tough situation to be in, guys.
Remember telling Detective Quinn on September 17, 2000.
Oh, wait. Hey, y'all. Also, I know Rumble don't know about this, but there is a detective show called like Atlanta Detective. I'm gonna put it in the chat for you. I mean, in the description. That gentleman that they just named, him.
September 17, 2013.
Detective.
That you told at 4533 that you told a few, and I'm just not gonna say it, but bull blank lies.
Hold on, wait. I'm about to get the detective name again.
Telling Detective Quinn on
Detective Quinn. Detective Quinn is so dope, y'all. I'm about to show y'all who Detective Quinn is. Oh my God, they got a series, Detective Quinn, Atlanta. It's called First 48 Hours. Oh my God. This is why I know this thing has to be some type of setup or something. They got us in a very soap opera. This, no way. Detective Quinn is so dope. Okay. This man is an amazing detective. I used to watch like First 48 Hours, and I kept seeing Detective Quinn. And when you listen to his stories, just like he came on the stand too. I was like, oh snap, they got Detective. Let me just show you. I know I'm excited because I'll be watching this type of stuff. Detective Quinn was on the First 48 Hours. Let me show y'all a little clip. This is TV One. I probably get a copyright for it. I hope they let me play it for a second. But let me just take this off the screen real quick and show y'all who Detective Quinn is. This is why I think this is the psyops. Detective Quinn is on an actual show. He talked about this show throughout the testimony, like, yeah, I gotta record this, that, and the third. But he's so dope in his approach that I like him. Let's watch him.
I don't know why the jury didn't convict, but they did. But it made me understand I had to get better. The lieutenant walked over to my desk. Everybody was crowded around. Here's your first homicide, Quinn. This brother got shot here in Atlanta. Was up in Grady Hospital for about 11 days. The ambulance that transported his brother from the scene, for whatever reason, they didn't call the police because they had done some errors on the transport. They didn't see the brother was shot.
Oh my God.
Great.
TV One present. Now this make it so dope to me, y'all, because y'all know I'm out here in Atlanta and y'all know I'm a nurse. Grady was one of the hospitals that I did not get to work at. That Grady is like Gotham City. I could only imagine what goes on. Grady, I'm gonna do one contract in Grady before I get up out of Georgia. But with that goes to say, this is Detective Quinn. This is my area. So this is why I'm like, wow. Oh my God. He's still on the streets in Atlanta. And I think what he does is audit the cops. Like, he's internal affairs. So in his position here, he was actually investigating the shooting of a cop that shot somebody when he testified on the YSL trial. So I'm showing you who Quinn is. This man is dope, y'all. Y'all gotta watch his shows. Y'all gonna love how he be like solving crimes and how he talk to people, man. He amazing. I know I'd be like, I don't mess with the feds, but I mess with good feds. I deal with the good people that's really there for the community, trying to clean up the streets, trying to give back. That's what I really respect. Okay, so let's just watch a little bit of Detective Quinn, and then we're gonna get back to our YSL, so you can see how this is like a psyops. This is really weird to me, but I'm just like intrigued of how all these connections are being made.
Hospital released the victim too early. He was only 11 days. He had 5 gunshots. He was grabbing nurses in the hospital, and so they got him up out of there. They just pushed him onto a bus. Yep. So the two chefs.
He said grabbing nurses. That's what I be having to deal with. trying to grab somebody's chest. They acting crazy. I'm having inmates in it. Oh my God. This is amazing.
Tubes down in him, sitting here, the blood, collecting in him. He went into full arrest halfway through the trip. He just died.
All right, we're gonna stop right there. I'm gonna put this little clip down there for y'all. I just wanted to show you who Detective Quinn is. Detective Quinn was somebody who testified on the YSL trial, and I just want to show y'all how this is really like a soap opera. Okay, so let's just get back to what Still was talking about this gentleman trying to basically get out of testifying. So this is just showing the last witness and what he did, and I think that's what they were trying to avoid with this new other witness, and I think that's why the judge thought it was okay for him and the prosecutors to have a private conversation with the witness. And we're going to get into that. We're going to get into a little bit of law, reading what the position is in Georgia for them to have these type of conversations, and what were they supposed to do legally, and what and you can examine what they're supposed to do legally versus what this judge is doing. Okay, so let's listen to this highlight. I had to just highlight Detective Quinn. Shout out to Detective Quinn in the first 48 hours. You keep me entertained. Your detective skills is dope. Okay.
September 17, 2013, that you told, and 4533, that you told a few, and I'm just not going to say it, but bull blank lies to the detectives. You remember that?
Mm-hmm.
I mean, basically, y'all keep asking me, do I recall this and recall that, remember this from 2013? I don't remember that from 2013. I keep telling y'all that. That has been my statement since I got here. Your Honor, I've been telling y'all, people constantly hit me with this, keep constantly asking me this and that and third about what's going on in 2013 and whatever. I don't remember. I don't know nothing about 2013. All I can tell you is, y'all got my name on a recorder, my phone number on a recorder. These people threatening me. They called on my phone. Your Honor, I done lost my job. I got a lot going on behind this here. I put all this behind me, sir. Everything that had going on with me, I put everything behind me and kept moving on about my life, sir. Your Honor, I can't continue to keep going on like this. I don't remember nothing from 2013, sir.
Mr. Bean, you have to answer the questions.
And he don't care that this witness is literally saying my life is on the line. I have nothing to do with this. Whatever happened in 2013, I don't remember. I don't deal with it. And they still trying to force him. They don't understand that people's life on the line. So they're literally giving these people these allegedly sweet deals to make them testify. And either way, they damn if they do, they damn if they don't.
Okay.
I'm constantly keep telling them and constantly keep telling y'all I don't remember nothing from 2013.
Sheesh.
I'm going to ask you because I have to lay a foundation. Do you remember telling Detective Quinn on September 17, 2013 on recording that you add a little more height when you speak with your wife and them from the jail, that you lied to them?
I remember y'all trying to assassinate me right now in 2024. That's what I remember. This is what I remember. All this going on right here got me up on this stand, talking about this and that third, all this extra stuff that's going on. Your Honor, am I on trial, Your Honor?
He's like, literally, you I got fired from my job. People coming after me. My wife getting on to me because I'm saying I was lying. I don't got time for this. You're fucking up my life.
Sir, you just have to answer the questions, unfortunately, at this point in time, okay? That's all I can tell you.
Am I on trial?
No, sir, you're not on trial. But you have been properly summoned here as a witness, and you're subject to examination until I release you.
I never consent to do none of this, sir. I ain't signed nothing. My name ain't on nothing. They come get me. Y'all don't threaten to lock me up. Hey, I got a family too.
Thank you. Let them go.
I mean, come on, y'all. I done told y'all.
You force somebody, and they do be trying to force people to come to be a witness, and if you don't be a witness, they'll try to lock you up. That happened in is that the Eric Snowden case? Well, I think the Julian Assange case, because they wanted the person to testify him. I think it was like some transvestite lady, and she was supposed to testify. She wouldn't testify against Julia and Assange, and they held her in court in jail too. They held her in jail just because she wouldn't testify. Y'all remember that? Y'all don't know that Grace Levi watch everything. Oh yeah, I'm praying. I'm praying and I'm watching. Babylon is falling.
I don't remember that from 2013.
All right, so we're going to stop right there. I think this is what they were trying to avoid with this witness that they were actually having these conversations with. And this conversation is known as, hold on one second, because they keep saying that. I had it. I'm going to make sure I'm using the right word in. Ex parte communication. Okay. So this is why I think they had the ex parte communication outside of court, where it was the judge, the prosecutor, and the witness. Not that witness, but another witness, the one that they made come back to court, and that is this one. Let's put him on the screen. This witness was not cooperating yesterday, or the few days that he was on the stand, and it seems like they had some type of communication with him to try to force him. It says Young Thug witness Little Woody attempts to get out of testifying for the RICO trial. So do we got it on the screen? Now this is the other gentleman. He's trying to get up out of there too, but I think he signed something.
Kind of say have it both ways, like you testify and then use that against you to indict you and prosecute you. Then we wouldn't have any faith that we need to have people come in and give testimony. So that's why they can't do that. They kind of can't go back on what they're going to tell you, So I signed the order. Now they've asked for immunity. I've signed the order. So basically, whatever you have to tell us, you tell us.
Say no more.
Now, we had this conversation. This is the conversation that they had in front of everybody. The judge explained some of his position. If I say something, will this be used against me? Yeah. What other conversations do they need to have in the background? Let's finish listening a little bit. Shout out to Law and Crime for this shot.
To testify, Mr. Copeland? Is that no? You have to say no on the record.
Say it again.
Do you wish to testify?
He said I can tell him whatever I got to tell him.
That's
so I testify.
You will testify.
Yeah.
Now that's today.
All right, sir. Okay. What we're going to do in just a second is I'm going to go ahead and I'm going to call for a jury.
That's the 7. That was the 7. Okay.
First, I will formally administer the oath to you, and then the state will ask you some questions. Okay. And then you'll be cross-examined at some point in time by potentially
some. My attorney before, because I think I just said the wrong thing.
Sure. I tell you what. Why don't you step outside and talk to Mr. Melnick?
My baby confused. All right, so what I'm going to do is I'm going to leave this clip for you guys so y'all can watch the full clip of what happened. This is about a 30-minute clip. The reason why is because I do have more snippets of what happened today, and that's about an hour clip. We're going to go into it. So we're going to be here for a little while. So that's why I said, let me move through this. But this happened on June the 7th, where this little Woody was trying to get out of his testimony. He like, wait a minute, like, I don't know if I can do this. You see what I'm saying? But he wanted to be just like the other guy I told you. The other guy, like, listen, my life in danger. I can't do this. I can't do this. So I think for them to avoid that happening, the judge thought that it was okay for them to have an ex parte communication with the prosecutor, the witness, without the defense knowing. So 7 hours ago, Young Thug attorney has heated exchange with judge over private meeting. Hold on one second. Little Woody takes the stand so Little Woody still took the stand today. After what happened, like where they held him in contempt, they try to keep on with these proceedings. So we're gonna put that down there in the description as well. That is brought to you by Law and Crime. It's a little clip. So let's get to where we at. Young Thug judge interrupts prosecution. Stay out of my business. Now, I'm going to get into this. Do y'all want to get into the proceedings, or I can show you how he deal with Miss Love? Young Thug lawyer has heated argument with judge prosecution. Now, this is one of the things where he gets on Miss Love. Let me show you the other side, but he don't really do too much. He really don't. When it comes to Miss Love, he love her. Let's put it on the screen. I'll show you how he treat this woman. And I'm glad that he had respect. Hold on, guys. I got a lot going on my screen. I'm glad he got respect for her, but this is just too biased for me. I wouldn't want to be in this courtroom with this shit happening. I would think my life is like literally over because it's like railroad. And the only reason why it's not being railroad is because that amazing lawyer, Mr. Still. And the rest of them, I'm going to give it to the other lawyers too. They follow a lead. Let's play this.
There's a total of 28 times where he does something like that. Literally, he says, "Do you remember explaining that that what you were referring to is at the hospital?" That
this is when most recently she was trying to get this hospital testimony in that allegedly was taken by Detective Quinn.
The police were telling us to lie, put thug in it. When you talk to Detective Lewis.
Okay, but that's.
So when he says, "Do you remember a thing that there's no evidence took place?" He is asserting that one, it took place, and then asking the witness improperly in front of the jury.
Did he ever talk to Detective Lewis?
No, that's just what I'm telling you, Your Honor. And then Mr. Steele gets here and says to you all this stuff and still never shows you anything to suggest that Adrian Bean talked to Detective Lewis.
This was after that. I apologize. This was the case that Quinn was researching, because Quinn was the person, like the internal affairs that was over the person who got shot. And they're talking about the detective that went to Grady to talk to the guy who got shot. And the guy who got shot allegedly was in the middle of robbing a lady of her car. And this lady, they knew. Yes, I've been watching it and they knew the lady. Okay. It is crazy. Okay, so this is where it is. So that's how Detective Quinn, that is what he was investigating, this shooting.
Mr. Steele, you want to respond to that? Because that's critical to me. I mean, it's critical in the sense that if there was no conversation between the two of them, then that would assume facts, not in evidence. Hold on, I'm asking Mr. Steele a question now. Just hold on, Miss.
Look at him. She trying to get some shit in that ain't even right.
On the recording that you just heard at the beginning, the first couple of minutes, and I don't have the time in front of me, it was not shown on the screen. Mr. Bean said when he spoke with the detectives or the authorities, whatever his words are, at the hospital. That's what he says.
Okay, but here's her beef. If you'd have said, "Who'd you talk to?" And he said, "I talked to the detective." Well, was it Detective Lewis? Was it Detective Quinn? Was it Detective whoever? What I think that the question assumes is that he did in fact talk to Detective Lewis, and he didn't.
I don't know if that's true.
Well,
I'm not conceding that.
Well, I'm going to tell you that I haven't heard anything that would indicate that's truth.
Yeah, well,
you have a good faith basis to ask that.
You haven't heard anything of who he spoke with. That's my point.
That's the point.
But you all can't. But you two, neither one of you can proffer that. It's not proper, Mr. Steele.
No, you see how he talked to Miss Love versus Mr. Steele, and it's actually Miss Love who's making a mistake here. Listen to the tone. Listen to this disrespectful judge.
It's not. It would be a.
Look how calm. Look how calm Steele is. I wish I could be like him.
Violation before me for you to put that in front of this jury.
You're not letting me finish. In the September 17, 2000.
You were saying to the court that you have a belief that there is another statement out there. There's not.
How could you say that?
Because it hasn't been brought up. If it gets brought up, then we'll correct it at that point in time. But right now, I'm going to direct you not to inquire that line.
You see? He said, well, if it gets brought up, we're going to bring it up then. But I don't want you to say nothing right now. And that's the same type of MO that this judge is using against Steele to say, no, you can't even talk about us having this conversation in secret because I don't need to know how you got it. Who was it? Who was it? We're going to get to that next, okay? I just want to show you the pattern of this judge's behavior. versus how he talks to Miss Love and how he talks to Mrs. Steele and the rest of the defense team. Let's give a few more seconds of this video and we're going to get into the meat and butter of what happened today.
You don't have a basis to do so. Well, go ahead and make a statement and see what happens.
Your Honor.
Go ahead and make a statement in contravention to what I've just told you. And I'm telling you that you will have some problems in front of me.
I'm trying to articulate to you.
You have told me everything at this point. You have told me that there's got to be.
You see how he argues back and forth with Mr. Steele, and he does not address Miss Love in the same manner. This is terrible. I'm going to keep highlighting this. I'm going to keep highlighting this because this man needs to be disbarred. Period. Disbarred.
Your statement. Now, if you find the statement, I will, one, apologize to you. Two, I will take corrective action. It's probably not going to be nice to anybody. But at this point, there's nothing for me to do other than if you don't have a good faith basis to do it, you can't ask the question.
Honor, listen. There is a recording between Detective Quinn and Adrian Bean where Adrian Bean says, I lied to your...
But we don't know what he lied about.
He says he lied about who he's talking about the car.
But we still don't know whether or not.
So basically what the judge is trying to do is keep this evidence in, and the judge and still is saying, look, the gentleman said he was lying. Okay, the whole thing, he was just saying whatever. And the judge is still trying to push forward to get this information in front of the jury. Look what Mr. Steele has to go through.
He had a conversation with Detective Lewis.
And I made it clear, it's 10 years ago.
But you said you had, in your conversation with Detective Lewis, that's what you proffer.
I said, what?
All right, let's get to it. Now we're about to pull up the video of what happened today. And again, I'm going to put this gentleman on the screen. I'm going to tell you, I got mad love for Mr. Steele. I couldn't find a picture of him by himself. Shout out to Mr. Steele. He is honorable. If anybody that I would want to represent me, I will want this man to represent me by all means necessary. Also, before we get into the clip, I want to send a shout out to Miss Ashley because she coming in hot. This was the wild card that came into the courtroom today. And I was like, damn. I was yelling. I'm telling you, I was like on a bookshelf. I was like, oh my God, look at this. All right, let's get to it. This is the exciting part to me of this whole broadcast of what went down today. Let me make sure that I got it. Okay, there we go. Because I had to record. I want to make sure that I had a true clip, my own clip. Hopefully it plays. Let's see. Okay. I'm about to get it on the screen. I'm so excited. I haven't talked about this in a while. Baby, it just boiled up today. Hold on. Let me make sure everything's good. Okay, let's get to it. I'm going to try to speed this up a little bit. This old bubblehead lady. Ooh, let me tell you. I love these men. I love these men that's fighting for YSL. I'm sorry. I'm trying to get to the clip. I had to do my own recording.
And it is not covered by.
Let's start. This is where it starts to go down.
And it is not covered by work product. There's only one way you could have gotten it. So I'm gonna ask you again.
Okay. First and foremost, you hear this is the judge hyperventilating right now. He's hyperventilating. He's like, how did he get this? Oh my God, my career is over. And before we start this clip, I got a surprise for you guys. This is my message to the judge. This is what's about to go down.
Why are you detaining me? You about to lose your job. You about to lose your job. Get this dance. You about to lose your job because you are detaining me for nothing. You about to lose your job. You about to lose your job. Get this dance. You about to lose your job. I'm Martinez. You about to lose your job. Get this dance. You about to lose your job. Get this dance. You about to lose your job because you are detaining me for nothing. You about to lose your job. Cause you about to.
It's worth you losing your job, Judge Glenville. Let's get to it. You about to lose your job. Oh, baby. Oh, I can't wait. Let's get to it. I'm sorry. I'm excited. This is some BS. Shout out to Mr. Steele. Let's get the clip playing.
And I respect that. And it
Let's
gives
go.
me no joy, but as you know, Georgia Rule Professional Conduct, please check me. Rule 1.6, comment 5 reads, and this is what I have. 1.6, I know what the rule says, but here's the thing. Well, I'm just, but you've got.
Okay, so right here, this is where you see the judge is just trying to gloss over the fact of the rule we're going to go over. I'm going to let him argue a little bit, but we're going to get into this rule in Georgia and what the judge was really supposed to do and how he's using gaslighting. This is gaslighting. When someone does something wrong and then they pick one thing that allegedly you did wrong to get the information. Oh, you shouldn't. It's like a boyfriend cheating on you. You should have picked up my phone. Why you pick up my phone when he got 10 chicks in the phone? Okay, this is what's going on here.
But in order, you need to please tell me
Look
who
at
you
him.
got it from.
Look at
I'm
him.
not asking you some
Look at him.
substance of anything.
You're about to have a heart attack.
But I need you to tell me how you got the information. If you don't tell me how you got the information, I'm going to hold you in contempt. Yeah, I don't want to be held in contempt. I don't want to hold you in contempt, but
Treating my baby like that.
This is so sacrosanct to have a conversation in my chambers parroted to you and others. It is that serious. Yeah. That's why I raised it.
You're like, yeah, it is.
Been there and it shouldn't have, sir.
Look at Miss Love. Oh, look at her. She mad as hell. Mad. Corruption. This is the corruption that happens in Georgia. Fulton County. Shout out to Fulton County. Shout out to Fannie Mae. Fannie Willis, let's say. I keep calling her the loan company. You know what I'm hearing.
That's a whole separate issue. And that's why ex parte conversations are recorded. Why would it be ex parte? It's ex parte under seal. It's ex parte because that's what the state asked me to do. It's just like when you asked me for an ex parte conversation. I've never asked this on court or any court to meet with me and a witness.
Now let's stop. Okay. Let's get into, I'm just going to read this to you guys. This is from a secondary resource, and this is Fact Cases. This is Georgia Rule 120-2-2009, Parte Communication, Georgia Rules and Regulation 2024 edition, okay? 1, except as required for the disposition of an ex parte matter authorized by law, the adjudicator may not consult a person or a party on the matter related to the merits of the adjudication unless on notice an opportunity for all parties to participate. All parties. This is Georgia law. This provision does not, however, preclude the adjudicator from consulting with the adjudicator's employees, such as law clerks, okay? Except as required for the disposition for ex parte matters authorized by law. Except for disposition. There's not a disposition that was going on between the witness, the judge, and the prosecutor. Continue reading. No interest person outside of the department may make or knowingly cause to be made to the department or any of its personnel who is or may be reasonably be expected to be involved in the decisional process or ex parte communication relevant to the merits of the adjudication. So no interest person outside of the department may make or knowingly cause to be made of the department. Basically, who is expected to be involved in the decisional process. No interest party in this ex parte communication should be the person who's going to be part of the decision process, i.e., the judge in this case. The adjudicator or agent personnel who or may be reasonable to expect to be involved in the decision process who receive, makes, or knowingly cause to be made a communication prohibited by this rule must place it in the public administrative record. So if the person who is going to be over the case is involved in this action, according to what I'm reading, it's supposed to be put into public record, administrative record. And when you're going to hear, the judge refused to do that. And all such must be in writing communication. Memorandum stating that the substance of all such oral communication needs to be made. All written responses and memorandums stated to substance of all oral responses. So everyone's supposed to be have a part in this and be able to communicate. So the defense team was supposed to know about this meeting, according to Georgia state law. Upon receipt of communication knowingly made or knowingly caused to be made by the party involuntary of this rule, the commissioner or the adjudicator may, to extent consist with the interest of justice, the policies underlay statutes, or the department rules and procedures. The only way that this can be superseded if it basically is in the interest of justice. We don't know. We don't know if he's guilty. Nobody has that. The policy underlines the statute. There's a policy. Ain't a policy. And the department rules and procedures require the party to show cause while the claimant's interest in the adjudication should not be dismissed, denied, disregarded, or otherwise adversely affected by reasons of such violations. Okay? Now, last part to this. The prohibition of this rule apply beginning on the date of the department become aware of the issue. This is why Mr. Steele brought it up today. Okay? Issues for adjudication, but in no case do they begin to apply later than when adjudication is noticed for hearing, unless the person responsible for the communication has no knowledge that it will be noticed, in which the case the prohibition applies upon his or her acquisition to the knowledge. So basically with this rule is that the person that's in charge, which is I'll be the judge, need to make everybody aware and put on notice if this was a hearing, if it was going to happen, and they didn't have a hearing. This was literally a personal conversation in the judge's chamber. The law is talking about, like open type of ex parte communication, where the judge was like, yeah, that's why the court recorder recorded it. And they said, when we get to it, all of the defense asked for a copy of it. And you're going to see what the judge say. So I read that in legal terms right off of Fact Case. I'm going to leave that down there for you guys. But I try to translate it so it can make a little bit sense to y'all. Y'all know I'm a legal researcher. I love to research law, figure out what it means. If I don't know what it means, I'll be pulling up on Black Law's dictionary. Okay? So I just want you guys to understand what ex parte communication consists of in Georgia. This is another case text. This is like a third reference. It's not a law reference, but they do have the law here. It says, once the case is before the court, no person shall communicate with the assigned judge related to the merit of the case without the knowledge and consent of all parties to the matter, provided that the judge may communicate with the judge related to the merits of the case at any time. The judge, so it could be another judge. That's why he wasn't supposed to be doing that. Oh, that's what it was supposed to could have been another judge. Okay. Where circumstances require ex parte communications are authorized for scheduling, administrative purposes, or emergency that do not deal with some submissive matters or issues on the merit, provided that the judge reasonably believe that no party will gain procedural or tactical advantage as a result of the ex parte communication. Bam. So you telling me about the defense not being there and the prosecutor's there talking to the witness and the judge that's not a tactical advantage for the prosecutor? This is according to Georgia Comp R in Regulation 16-1-2-10. We'll put that down there, okay? And so again, the judge makes provision to promptly notify all other parties of the substance of the ex parte communication and allow an opportunity to respond. And that is what Steele was trying to say. So this one was more lame terms, the definition. Should a judge receive a communication prohibited by this rule, he or she shall notify all parties of recipient or of the receipt of such communication and its context. OCGA 50-13-40. If you didn't know, Judge. So stop trying to railroad them into thinking that they were wrong because they received the information, and then he's trying to make it criminal, basically saying still was eavesdropping. So let's finish listening. Now you understand what ex parte communication means in Georgia, because it's got different application in different states. Here, like in California, the ex parte is much different. It's a little bit wilder, but at least here, that the judge was supposed to put everybody on notice, and that is what Still is talking about. Let's get it. Let's finish listening.
Sir.
And that's why this guy right here is shaking and huffing and puffing.
You're straying off the issue. I'm not. The issue is how did you get this information? I understand this.
Ooh, you
What
mad?
I'm trying to ask you is, if you look at comment 5, this is how I understand the law. You can't violate something and then use privilege. Okay? I'm not violating.
He's already trying to say that Still did something criminal. And we're going to talk about how the avenues of how Still could have got this information without violating law. We mentioned it. The jails talk. So all it takes for that gentleman that they put in contempt, that they had in that jail suit, that came back out in the jail suit, who had the conversation with them, was back in that jail, sent a bird to Young Thug, like, listen, this is what they did. They putting the pressure on me, this, that, and the third. Young Thug, all he had to do was tell his lawyer. In which way was the lawyer wrong in that aspect? You can't control what jailbirds say to each other. You put that man in jail. You think they can't talk to each other because they're across the quarters? That's what I think happened, in my opinion. Definitely no, Still didn't have no daggone recorder in there. And if he did, it's a one-state recorder in Georgia, but I know Still didn't do that.
Okay, but that's why I'm saying, how did you get the information? But just listen to what I'm trying to tell you. You're saying the privilege would occur. The privilege in 1.6 would occur if you were in the right place, right time to begin with. You weren't.
You don't know.
I'm just reading from it. But if I'm reading it wrong, I'm not trying to. It says 1.6 applies not merely to matters communicated in confidence by the client, but also to all information gained in the professional relationship, whatever its source.
So he's telling the judge right there, this is client privilege. And I can't tell you, he's giving you an idea. My client told me.
So you're asking me to break your order again, maybe. You're asking me, yeah, I'm not saying your order, but to give you information, and you're saying it's not some substance, but I'm telling you, I can't do that under the bar rules. All right, well, I'm going to hold you in contempt. And you can think about it. 5 o'clock today, we'll see where you are. That's staying on that point. Because no, that's not what I understand.
Look at him. Hold on, y'all see his face? Like, nah, this is some bullshit. Look at his face. Look at his face right here walking by. He like, nah, this is some bullshit. Not still. Don't be mad at the clerks in there, them people in there, because I had talked to one of the bailiff. He's like, I was like, you was about to lock me up. He's like, girl, I didn't want to. It's that judge. You can't be talking to her like that. I was like, you was about to lock my ass up. Look at his face.
I understand.
Wait, let's get to his face. His ass. Look at
time to begin with. You weren't. Let me tell you, I'm just reading from it. But if I'm reading it wrong, I'm not trying to. It says 1.6 applies not merely to matters communicated in confidence by the client, but also to all information gained in the professional relationship, whatever its source. So you're asking me to break your order again, maybe. You're asking me, yeah, I'm not saying you're
ordering him
to give you information, and you're saying it's not some substance, but I'm telling you, I can't do that under the bar rules. All right, well, I'm going to hold you in contempt. And
look at his face.
You can think about it.
Check it out.
Today, we'll see where you are. That's staying on that point.
Look at him.
No, that's not what I.
He's like, nah. You saw the little shake on his head, like, shit. This is bad.
Said, I asked you how you got it. You can't do that. Yes, you can. Because I have an idea how you got it. Well, I have an idea how you got it, but that's improper. Sir. Your idea may be wrong, and you're asking me to
So
Listen, I told you.
what I'm thinking the judge is thinking is that the lawyer told him. Listen to what the judge say.
The first time. And I'm not sure.
I don't want to hold you in contempt, but this is that serious.
Judge,
You cannot eavesdrop and get information that was not meant for you to hear at that particular point in time.
How he accused that man of eavesdropping?
And listen, I'll do whatever you want to 5 o'clock or thereafter. But what I'm trying to tell you is, Your Honor, this is so serious to me. We need a hearing. I'm moving for a mistrial. It is my understanding, based on information belief,
From whom?
part of it.
From whom?
Well, I'd like to get the substance first, and then we'll keep
Okay, well, then you'll be in custody until then. Because you need to tell me how you got the information. I'm not asking you what was said. You've already kind of given us some snippets of what you said. That tells me that somebody parroted that information to you. So,
but you're assuming something because I told you already.
well, then, other than if you were sitting, unless you were sitting in there with a recorder or Miss Love or Miss Hilton or one of the deputies gave you that information, or Miss Weaver shot you a rough copy of the transcript, there's only one other person that's left.
Well, Your Honor.
And if that person gave you that information or shared that information with you, she probably violated privilege.
Well, let me tell you.
What privilege? What privilege? He's trying to say it was the other lawyer, the guy, the witness lawyer.
Two things. One, I don't know how that is a privileged communication. It shouldn't.
Well, it's because she has a client she's supposed to represent.
You don't know.
Anyway.
See, he like, what are you talking about? What are you talking about? Are you trying to say, excuse me, y'all, this is ginger beer. This is not beer. This is a non-alcoholic sparkling ginger. Okay. So I'm over here watching the football game, drinking my ginger beer. Okay. But you see how the judge is trying to make it like it's the lawyer. And he's like, what are you talking about?
I'm not going to have any further conversation with you about this. I want to know, the question still remains.
Oh my God.
I want to know who gave you the information?
I'd like to know what information happened outside of presence. That's really it.
Look at this. Oh, I can't stand her. Look, she about to get up. She about to get up.
To again declare a mistrial based on.
Okay, and I'm going to deny your motion. I'm going to deny your motion.
I understand that you spoke with a witness outside our presence.
And when yes, I had an ex parte conversation.
Don't you touch Mr. Still. Look, she over here praying like this about to get ugly. Look at her over here. She like, damn, Lord, this about to get ugly. I think I like Mr. Still. He about to go to jail. Oh shit, I'm messing with the devil. I'm still trying to figure out about this dark skinned one right here. I don't know whose side she working on for real.
I'd like to have that all on the record. All right. I mean, I don't know why that's so hard to do. If nothing happened bad, that's fine. But you're acting like, tell me who it is and don't talk about the substance. Why can't we have an issue that was outside of presence?
Sit your ass down.
Sit down. Because you got some information that you shouldn't have gotten.
You standing up for?
Well, we can. That's for another day.
But why?
That's for another day.
It's stressing me out, y'all.
I didn't know about this stuff.
That's for another day. So
I raised it as soon as we found out about it. Well, I gave you the case I'm relying on. I assume you read it. If you didn't read it, you should read it. It's a material part, a critical part of the case. When a judge speaks with a witness outside the presence of the accused, the court has said it's right there in Division 2. That is a material or critical part of the case. And it's an automatic reversal.
Mr. Steele.
But you're acting like it's
Mr. Steele, that is not when that is not the case when somebody discloses information in a ex parte conversation that one of the parties lawfully asking to hold.
You're not supposed to have communication with a witness who's been sworn.
Nope.
You know, I'm not telling you. I'm just saying if you read the case, I'm assuming you read it. That's what it says. And you did it.
The state wishes to be heard.
You said.
Oh, he's so disrespectful. You see how still talking? He's like, all right, that's enough. The state want to be heard. You see how disrespectful this man is?
And what I'm trying to get to is why did that happen outside of presence? And I need to have the.
I'm glad I reacted before I got on screen because I was yelling. I was yelling at them.
I'm respectfully requesting the transcript that you mentioned to be given to us so we can really understand it. And then anything that is not on the transcript, if anything, that we understand what happened outside our presence.
Okay.
So he's asking for the transcripts of whatever they talked about.
And now you have put it where somehow I have to reveal, and I told you the first time, I'd be breaching 1.6. And I know you're assuming something.
I don't think you're breaching 1.6.
You don't know who told him.
I'm not hiding.
You don't know who told him. So you can't tell him that he can't use 1.6, attorney-client privilege. You see what I'm saying? The judge runs with whatever is in his mind and try to discredit Still all the time. Still, we're in your corner. We got to go down there and protest on the weekends, okay? I'm going to tell you why we got to protest on the weekend, because Still about to do a big with YSL.
And you can't hide behind. Yeah, but the thing is, I think you got this information. Somebody disclosed it to you, and that's the only way you could have gotten it.
What I got.
Because unless you're sitting there, you're eavesdropping. So you can't use something ordinarily that you had no business getting to begin with, and then stand on, well, hey, we didn't give you the information, or the party didn't give you the information. So,
Your Honor, that's the issue, isn't it?
well, that least be told. But
In that aspect right there, I wanted to say, you about to lose your job, Judge Glenville. You know what you did was wrong. You're trying to cover it up. This is going to be the end of your career, sir.
But right now, we don't know
words.
why we were excluded from that.
Mr. Steele,
And I want that to stop.
Yeah,
Mr. Stop.
Look, Judge Glendale, let me send a message to you. You on a level right now of Fannie Willis. If you got Miss Ashley about to come down on you, you know you're about to lose your job. I don't care. I don't know why. I love Ashley too. I love Ashley Merchant too, because anybody who's honorable and do the right thing and whistleblow on a BS. Now, I don't know if it's political or whatever, but truth is truth, and we need to know the corruption. Shout out to Ashley Merchant. Let me put her on the screen real quick. If y'all don't know who Ashley Merchant is, one of my favorite girls. Just my favorite girl. Go Ashley. Go Ashley. I'm sorry. I like her. She's fierce. Let's go. That's what I'm talking about. Fierce and honorable. Let's finish listening.
Just right.
Just stop at this point in time. Because
Article 1,
because you already said that. You've already said
Georgia Constitution.
and we have the right to be present. All right, Mr. We're not waiving any. Yes. Now, Ms. Love?
No, I think I fast forwarded this. I did not want to hear nothing she had to say. No, I'm not about to listen to. Oh, yeah, this is what she said. I did.
Okay.
Miss Still, Miss Love is trying to come up with a punishment for Still. Who the hell is she? Listen, I did record this because she made me mad, but I recorded this one.
All right. Yes, ma'am.
Hurry up.
I
Talk
am
faster.
disturbed
Me too.
by Mr. Steele's representations to the court. The court has inquired. We have no way of knowing what it is or who it was that disclosed information that was contained within an ex parte conversation. Not only was there an ex parte communication between that we requested as a state to be on record with the court, but there was communication made, I believe, to a person and his lawyer.
And how was it on record to the court when the defense don't know?
I don't know that the reason that counsels took the podium was to address that particular issue so much as it was to try and assert an inaccurate, what he calls fact, and put it out there in the open as if it were true. But we certainly have the right to request ex parte communications. That's why we ask that the court reporter be present. This is a matter that the defendants did not have a right to be a part of, as this was a matter regarding a civil contempt that the court imposed upon a person for not obeying the court.
So basically, they were trying to enforce on this witness and let him know, if you do not come and testify, you're going to jail. You'll be in civil contempt. And that's what they were trying to do, pressure this person allegedly.
Directed. the state read the case that Mr. Steele cited. It does not stand for the proposition he asserts that it does. And regarding further legal support for our position, we would provide that to the court, but we are more concerned that information that is disclosed in an ex parte setting gets relayed to the parties who are not privy to that. The whole purpose of the ex parte request was so that that did not happen. And
that's not how it's supposed to be. No, that is not the foundation of the ex parte request. We already explained it to you in the state of Georgia. Everybody needs to be aware. So what she's doing is representing the law incorrectly, and she does this all the time. And the judge let her
express on the record our concerns and our reasons for concern regarding that. We believe that without more information about how that information got relayed to the defendant,
doesn't matter.
We cannot make the kind of assertion I'd be inclined to make. So
you can't.
Before making the next set of assertions, I would need to know how that information.
You don't need to know nothing. Who are you? Y'all shouldn't even have that time. I need to know who told. Nobody, and it's none of your business. You shouldn't have been having the meeting. If you did, everybody should have knew about it.
Was made privy to them, to counsel for the defendant. We did not.
You see my face?
Or outside of the rules of professional responsibility. And if need be, we will reach out to the state bar ourselves and ask what the appropriate remedy is for everything that has happened over the last 2 days or the last 2 work days, because we are extremely concerned. We have observed a number of actions on the parts of a number of people that I am not comfortable stating publicly at this time, but that would appear to call for being addressed.
All right, this is what we're about to do, because the clip that I put together was an hour of what happened today. I'm going to edit that clip up and then I'm going to put it up separate. It's going to probably end up being 50 minutes or so. But what I'm going to do is get into the best part of waking up on this video. And that is when, now this is when all of the lawyers come up right here and start asking to get the case, this a mistrial. Everybody's asking for a mistrial. He takes a break. He said, we're going to take a break. Still sitting here. We'll listen to this.
That's not what happened. That's not what happened. I'm just telling you, that's not what happened. We are not obligated to simply accept that there's been no violation. We believe that there has to be all. Okay, well then you
and they're making requests. They're making requests for the transcripts of this ex parte communication, and they're making requests. They're going to make requests for today's transcript, in which all of that is going to be denied by the judge.
No, we're not doing that at this point in time. So you'll have a choice to make. All right, take Mr. Steele into custody, please.
And this is when basically he was saying that you can't move forward with arresting Steele because he needs to be here to represent Young Thug.
That's not what happened. That's you can do the best you can at this point in time, because you don't get to extort the court. That's what you're attempting to do at this point in time. Sir, yes, you are. What you're trying to do is, I'm not going forward if I don't get this. You know, it doesn't work that way, Mr. Adams. And I'm telling you at this point in time, I would just kind of govern yourself accordingly.
You ain't
Sir,
shit. He ain't shit.
I'm telling you.
I'm sorry, y'all. This judge is terrible.
As the court, under these particular circumstances, everything will come out as it should. I don't think, sir, I don't have enough information at this point in time to address it. I don't. But I'm telling you at this point in time, there is nothing that was given, said, whatever, this morning. That is there any accuracy to some of the information? But sir, I don't even know. Your co-counsel won't even tell me who said whatever.
Because he don't have to.
And the challenge I'm having in this particular circumstance is that is such a violation of the sacrosanctness of the court's chambers and an ex parte conversation. You're just glossing over that. You're glossing over that in its entirety.
The witness does not have the right to hold up any etiquette or anything to your judge's chambers. You don't know if the witness is the one that told YSL. So you're making assumptions, Judge.
No. It's not, sir. It's That's not what happened. That's not what happened. That's not what happened. That's not what happened. I'm just telling you, that's not what happened.
Respectfully, we are not obligated to simply accept that there has been no violation. We believe that there has to be.
Okay, well then you made it. No, we're not doing that at this point in time.
Oh my
So
God.
you'll have a choice to make. All right, take Mr. Steele into custody, please.
Look at my babe, yo. Mad disrespectful. They mad disrespectful. That court disrespectful. Look at YSL. Young Thug all thick. I told y'all, look at it before and after. He done got mature in the face. You could tell he aged a little bit.
Okay.
Shut up. You hear her talking about, I want to do some research on what is the appropriate approach to this punishment or some shit. Who are you? That's what I'm saying. This is a zoo. This is ridiculous. Can't stand her. They trying to lock my man, Mr. Steele, up. Ride or die, Mr. Steele.
Yes, sir. You certainly may.
Honorable man.
Mr. Williams does not wish to go forward without me being here. You are removing me against his will, my will. You've taken away his right to counsel. And you're conducting material parts of this trial without me present, and I can't learn about it by watching online. So for that reason, additionally, I asked for a mistrial.
That's
Soon
right.
you deny, but I'd like you to deny our motions.
For the 100th time.
I've denied your motion, but I'll certainly take that under advisement, sir.
He's so disrespectful. Now it's about to go down, y'all. It's about to be a straight triple football play coming
We're going to be in
on.
recess for the next 5 minutes.
They go on recess, okay? And then we're going to see what happens. Like who comes in. Hold up. This is the best part, y'all.
Just continue to come back.
So this gentleman is done. He's tired. He's been sitting there 2-3 hours. This wasn't a 5-minute recess. They about to let him go home.
Give your testimony. All right, we can let Mr.
This
Copeland,
man done right here. He done. Stick a fork in
be
him.
released and processed.
He needs some milk.
Say again.
Let's get to it. It's about to get good. I'm trying to fast forward to some stuff here. Y'all can see me playing around with the screen on the side.
I'll also make a copy of it. The next court can give it in order. This evening.
I'm mad.
All right.
All right. So this is the best part. This is when Mr. Steele come in with his defense, his lawyer. Now, this is so dope to me because you got to listen to how many lawyers are waiting outside for Mr. Steele. They came in like a football team. I'm talking about unity. Like they about to take this Fulton County down. Listen, let's go. Let's go. This is where I got excited. Come on.
Criminal defense lawyers.
Okay, there you go. Ooh, let's go. Let's go.
Okay, Mr. Steele, are you willing to tell me at this point in time who it is that disclosed this information to you?
So I ain't snitching. No. No, no, and no.
So I'll wait on that.
Gacko is outside.
I'm asking you, sir, because they can, this is for you. It's not to the Georgia Association of Criminal Defense Lawyers. Okay, and that's, okay.
You said to me, you figured out somebody told me this information, and you somehow said it is privileged, which I can't imagine. Or I eavesdropped. So to me, eavesdropping is a Title 16 crime. So they brought down lawyers. But they brought down lawyers. The lawyers are not allowed into your courtroom.
No, we just,
Not in your court.
we just don't have any space, Mr. Steele. And plus, they're welcome to go to 8H. I mean, I told Sergeant Ingram that we can let in as many as we possibly can, that we'll fill up our benches at this point in time. We won't violate our security protocols, but that 8H is available. And
8H then has to have a right to counsel. If they're here, and I'm not going to.
do you have an attorney that's here for you, sir?
Yes.
Sure. Ashley Merchant is here.
Okay, all right, well, Mr. Merchant, that's fine. Actually, we're gonna ask.
Put on a glass. Yo, hold up. Let me just tell you this.
All right.
When T said Ashley Merchant, I was like, oh, snap. Touchdown. What the fuck is going on, right? I got so excited. This is ridiculous. Let's finish watching. Ashley Merchant is coming. She coming for you, Fannie Willis.
Merchant, good to see you as usual.
She coming for you, Mr. Glenville.
I have told your client, you represent Mr. Steele, is that correct? For the purposes of the contempt, I've entered the order. I've entered the contempt already. I'm entering the order. I'm about to enter the order.
I wish I could be
I held him in
this
contempt earlier from
like
today's
that.
proceeding by him not telling me who it is he got this information from. I'm not asking him for any of the sum and substance of the communication. He's been disclosing that, however, and that's why I kind of want to know who told him that. So if he tells me who it is that disclosed that to him, he will be able to purge himself of that contempt, and he's done. That's the only thing I'm asking for at this point in time.
Let's go, Ashley.
If not, then
Let's
as
go.
you well know, as a criminal contempt, there's no supersedes bond, there's no appeal, and I'm going to put him in custody for this evening. And if he wishes to, which he can still purge if tonight Keith Adams emails me or you email me and tell me, well, it was X.
God.
So I'm going to give him as much flexibility to purge himself of this contempt. Only thing I want is, because of the way this information was disclosed, it is troubling to the court, and is very, since it was a ex parte communication. We won't get into the merits of everything else that Mr. Steele has proffered and everything else, but that's the only thing I'm trying to do at this point in time.
I'm disgusted.
I've asked your client for the last time if he would tell me who it is that disclosed that information. Please. Microphone, it'll pick up, madam.
Oh my God, look at these people. I love them. The reason I'm telling you again, I love Ashley Merchant for what I know, because she blew and really set up, what happened with Miss Willis, showing the controversy that was going on. And it was a hard position for her to be in. They all work together. They literally see each other all the time. So she had to put herself in a bad situation, being in the clutches of Fulton County and having to basically go against Fannie Willis. Okay. Go, Ashley. And her and her husband are lawyers and they work together. So her lawyer is like her back counsel, the one that be getting the work done. Like, they both get it done. But I just love, like, what I found out about. I really, really respect this woman. Until she act like a fool, I respect her for what she's doing right now, honest. Because they all act like a fool at one point. Somebody gonna do something stupid.
Yes, ma'am.
Is it on now?
Yes.
Okay, great, thank you. Judge, just for the record, is the criminal contempt, is it criminal contempt that you helped him in?
Yes, ma'am.
Okay, and you said you had a hearing earlier today.
With criminal contempt, I told him what the contempt was, and that was, he refused to order the court. If counsel, as you know, if the court orders you to do something and you don't, that's criminal contempt. So I've asked him several times, please just tell me who it is that told you. That I didn't ask or inquire about anything that was said. I just want to know who it was, because he's got too much detail of this particular alleged conversation from the court to be concerned about it. So.
And Judge, since it is a criminal contempt, he is entitled to due process. He's entitled to a hearing, entitled to an actual show cause, entitled to the allegations actually written, entitled to a witness list. We're entitled to present our own witness list.
Whole proceeding.
Oh, no. Criminal contempt is different.
It is.
So you're going to see the lawyer, Miss Ashley, correct the judge on what he's actually trying to pursue, because the judge is trying to mix criminal contempt with civil contempt. And watch how she clarified this, like, baby, let's go. You're trying to get two things at one time mixed up. And that's what he does all the time. And Mr. Still always catches him out with the BS.
On the spot. So he's gotten the due process he's going to get. That's on the spot. I told him. Plus, he's had all day to tell me who it is that is it. So a little different, Ms. Merchant. I won't disagree with you, but
Well, and
okay.
Judge, just for the record, it's that's direct. So what you're holding him in is in direct criminal contempt.
Yes.
The issue with the direct criminal contempt is whether or not to actually hold a hearing now, whether or not it needs to be held immediately. And the problem is, if you hold him in direct criminal contempt, as you're saying that you did, you are a witness to that proceeding. And so it has to be referred to another judge. Doesn't require recusal. You actually have to sua sponte send it to another judge because you're a witness to the proceeding.
Show me the case law that says that, Ms.
Yes,
Merchant.
it is Henry McCarty. It's 152 Georgia Act 399. And it says that is one of the cases. Also, two other cases, Henry Adams, 215 Georgia Act 372.
One second. Give me the name of the first case again. Henry what?
Do you want just the number, Judge?
Yeah, I would. Thank you.
215.
215.
Georgia Act.
Georgia Act.
372.
Okay.
Also 215. Georgia Act. 349.
Okay.
That's Adams and Hasty.
Don't take too long. Stay long, steady wrong, Judge. Go ahead, hit him with the case law, Ashley. They was already, it was. Did they say it was 25 of them outside? Did y'all miss that? It was 25 lawyers outside ready to come in.
More current than 1994.
Hasty is 94. Unfortunately, contempt of attorneys is not a common proceeding, so most of the cases are a little bit older.
Don't be too quiet, Judge. 25 of them outside waiting for y'all. They brought a football team of lawyers outside. They only let Ashley in, but they had 25 of them waiting outside. They're gonna let one more person in.
I'm not the only one here. There's quite a few other lawyers that want to be present in the court. There's about 20, 25.
Put your glasses on.
So
what'd she say?
Like I said, since you were representing, that's fine. He told us, Mr. Steele told us that.
25.
Anybody else, because I have security concerns as well, and we have to vet people to come in, then they can go to 8H, and they can certainly watch the proceedings from there.
And Judge, for security purposes, they're all attorneys. They're all members of the bar. I can give you all their names.
You still would have to be searched. You still would have to be subject to the court protocol.
And also, there's room in the jury box, and then there's room in the courtroom. So we would ask that they be.
I don't want them in my jury box. Okay.
He mad as hell. Look at him. He about to get mad at her. He getting mad at Miss Merchant now. Go ahead, think you about to rule shit. You gonna lose your job. Georgia's still a Republican state. I don't give a damn what they thought they won. Watch what happened. That's what needs to happen in Dalton as well. Because it's a Democratic state. Y'all need to get some Republican there. I'm being honest and come in there and get Tiffany Henyard ass. That's the only way y'all going. Y'all better put the others against each other. Because if Democrats go after Democrats, ain't nothing gonna happen. The reason why it's so spicy out here in Georgia is because this is a Republican state, and you got the Democrats trying to take over, and you got Fannie Willis think she going after a Republican ex-president or a upcoming president. This is shenanigans here. But I think more check and balances may get onto Georgia based on the fact that the Republicans is in the ring fighting. They fighting. It is what it is.
One additional attorney come in, then Alex Susser. And we're here on behalf of DACL for our strike force. He is the chair of the strike force. I'm the president of the Georgia Association of Criminal Defense Lawyers and also a member of the strike force. So can he come in as another attorney co-counsel?
He's still trying to figure this shit out.
Great. Alex?
He's trying to figure this out.
Thank you, Judge.
He like, what the hell this case say? Yeah.
Henry Adams, I think it has two issues. One is the motion for disqualification.
Look, Love gonna have a heart attack over there. She can't speak. You can't speak with Ashley in the room. Pop up on Ashley like that. Okay? Pop up on Ashley like another woman like you do. You won't do that. Sit your ass down.
That was in, that was 215 Georgia, 372.
Sorry.
Yes. And there's several others when you're ready.
My. Go ahead, Ashley. What you was saying? Come on. You still reading the case, Judge? Hurry up. He been reading for a little while, trying to catch up.
Maybe want to have to.
Let's fast forward a little bit.
And in this particular case, so I distinguish your two cases that you give me thus far.
So those were only the initial two. I had a couple others.
Okay, go ahead.
As well. Yes.
Let's go.
So Ramirez versus State, it's 279, Georgia 13, 2005. It also
You said 279 Georgia 1, I'm sorry?
Georgia 13.
Georgia 13?
Mm-hmm. It's a 2005 case. And it defines direct contempt and explains that it must actually interfere with the proceedings to be direct. So there's also a couple other cases on it.
So what he's saying is, if you call it direct contempt, she said it has to interfere with the case. I haven't showed y'all that when he sent Mr. Still out the first time, he continued with the case. You heard his Mr. Still partner like, I can't move on without him. And he's like, well, you're not going to hold us hostage. You're going to move on. So this is what she's saying. You don't even meet the definition for direct contempt. Let's move on.
See, but you all are covering under,
Look at you.
I'm sorry, Judge?
Hold on.
Look. Excuse me? Go ahead, Ashley. That's how I am at work, y'all. I'll be more like emotional here, but that's how I'll be at work. I'm like, excuse me? What did you say? Get him. Get him. Let me fast forward. He's still trying to figure this out for a little while. Read and read on.
And now it's punishment summarily without further notice. I already did that, Mr. Steele. He's already told me. I already gave him the opportunity to do that. So we had that conversation this morning already. So
and Judge, there's a couple different issues. First, the question is whether or not you need to have that hearing now. I know you're saying that you had the hearing earlier, but regardless, he was entitled to have an attorney at that point, and he didn't have it. So the question is initially whether or not you even need to hear this now. And some of the cases I've cited, along with some others, say that a summary proceeding is not necessary in a case like this. And the best evidence of that is the trial has continued. It has not stopped this trial. So for you to hold a summary hearing of direct contempt, the court has to be able to state how this interferes with your ability to administer justice in this case.
I can tell you because it is a violation of the sacrosanct nature of the court's ability to hold ex parte conversations without those being broadcast to other people. And as to how that information was disclosed, that's a real problem. That's why it's such an issue for the court at this point in time.
Judge, Mr. Steele has a right to make a motion like this. If there were ex parte,
he does.
I'm not
She
saying
gonna
anything, but
look. Miss Love gonna have a ball. Miss Love gonna have a ball spot on the back of her head. She keep itching her head like that. You see her ass stressing. Go ahead, cause you about to lose your job too. I don't know how, but the judge gonna go first.
But he's kind of put himself in a particular position he's in.
No, Judge, I don't agree. I believe that.
I'm gonna disagree. Okay.
I believe that the court has put him in that position.
No.
He cannot be held in the law states, McClary, which I cited to you earlier.
It is true that direct summary contempt, which arises in the presence of the court, intends to scandalize it and or hinder, obstruct the orderly present.
It didn't scandalize nothing.
Justice. The preservation of order and decorum of the court is exempt from due process requirements of notice and hearing. That's even Moody, goes back to 1974. So I believe that Mr. Steele, he can file whatever motions, but his particular actions.
How he tried to say that Mr. Steele still tried to scandalize the court when you actually did something unlawful, and he just brought it to your attention that he found out. How? This is the how? How? This is the BS when they talk about politically correct and you can't tell the truth.
In this case, I just want to know who.
None of your business.
That's all. I'm not asking you this to release.
I'm gonna say YSL told me.
Tell
Young Thug.
But I just want him to tell me that.
And Judge, so that's what you want, but that does not conflate to a contempt. Your desire for him to answer your question does not mean that you have the power to hold him in
So
contempt.
you can come into court, Mr. Merchant, and not answer a question of the court, not be found held in contempt?
If it's a question that the court is not permitted to ask, yes.
Okay, well, this is a question the court's permitted to ask.
And it's our position, if we had a hearing, we could explain to the court why he is not required. First of all, the court accused him of eavesdropping. That is a crime. He has a Fifth Amendment privilege against answering those questions. Rule 1.6 protects all confidential information that is gained
Self-incrimination.
not from your client, but in representation.
The Fifth Amendment is self-incrimination. You don't have the right. They don't have the right to make you self-incriminate yourself. That's the Fifth Amendment. Okay, know the Constitution.
Representation of your client. He has the ability to protect that information, but we don't even need to get there because he can't be held in contempt, and you can't threaten him with contempt for presenting a motion in good faith. He presented a motion in good faith that he believed there were ex parte communications.
Love.
You are a witness to that because
head.
it's my understanding that you were part of those ex parte communications. They can't be ex parte if you aren't part of them, by nature. And you have to be involved. Therefore, you have to be a witness. So you are a witness. You cannot also.
But you got the information. But here's the thing: you got the information allegedly from.
We still saying the same thing.
Improper methodology. I'm not saying that he eavesdropped. Okay, I said that one.
Wait, so how do you know it's an improper methodology if you're saying he didn't eavesdrop? I just gotta, guys, we getting to the end. I'm just feeling some way.
One of the things is it's either one of two ways. He either eavesdropped, which I don't believe he did at all. I don't believe that.
So why would you say it?
But I do believe that somebody did tell him what was the sum and substance of the court's conversations, and that would not be permissible.
Judge, let's just back up for a second. He makes a motion because he has reason to believe that there were ex parte communications made. The court has a duty, if there are ex parte communications made, to alert counsel. He shouldn't have had to learn it from wherever he learned it.
I think he caused that particular circumstance.
How did he cause the situation when y'all had the ex parte communications? He's blaming on Steele for finding out.
That he had a conversation with somebody and he got some information that he shouldn't have had to begin with. So, Ms. Merchant, I'm of the opinion I'm going to stand on my ruling at this point in time. I'm going to hold him in contempt. So, at this point in time, is there anything else you want to tell me?
Yes, Judge. There's quite a few other things. So, first of all, we would ask for you to be recused from this case because you are a witness necessarily. It cannot be an ex parte proceeding without being a witness. So you are a witness to this proceeding. Therefore, yes, to the contempt. To the contempt. You are a witness to the contempt. So you have now, and if it's criminal, which is what you're saying it is, Mr. Steele is entitled to all the same due process rights that Mr. Williams and every other defendant in this courtroom is entitled to. He's entitled to those. One of those is to have a fair and neutral judge decide his case. One of those is to have a judge who is not also a witness in the proceeding deciding whether or not he's in contempt.
Go ahead, Ashley.
This needs to be heard by a different judge.
Yes. Thank you, Ashley. Thank you.
Mm-hmm. And he has the right to subpoena witnesses. He has the right to an attorney. He has the right to due process, notice, a show cause hearing, notice of the alleged violation, whatever rule it is that the court believes, and a hearing where he can call you as a witness. You can testify.
Look, get up, love. Go ahead, get up. Why you ain't popping up out your seat now? Miss Love, pop up now.
You are necessarily a witness. You can't, for it to be ex parte, you have to be a witness. It can't be both ways.
Pop up. Pull up on her. You won't do that. Everybody quiet. He said he will let appellate court decide that he's going to move forward regardless. Did y'all hear this, Lord Judge? I'm going to shut up. Y'all probably didn't hear because I was talking. Let me shut up and let y'all listen real quick.
Court believes in a hearing where he can call you as a witness. You can testify. You are necessarily a witness. You can't, for it to be ex parte, you have to be a witness. It can't be both ways.
I'll let the appellate court decide that. So, anything else?
No, we'll file a notice of appeal. And
Okay.
we need to have the order reduced in writing.
I'm going to do that right now. I will state for the record at this point in time that Mr. Steele has in fact, or has filed, and I will note this as part of the record in this case.
Oh, this is Mr. Steele Fallon's, and then they're going to give him his punishment. Check this out. I would love to have a lawyer like Mr. Steele. Hard body.
He's filed a motion to set aside the contempt. He's filed a motion for a superseded bond, and he's filed a notice of appeal, all of which I will include as the next court's exhibit in order. But I'm reducing the contempt to writing. And I mentioned earlier, he can purge himself of the contempt just by telling me who it was, and he can do that this evening. He can do it. He can do it right now. He can do it at any point in time. If not, I'll revisit the circumstance on Friday.
And Judge, we would ask that you grant bond. At this point, grant him a bond on that issue.
You don't get a superseded bond on a criminal contempt, though.
Is the judge's
You can grant him a bond.
is the judge's discretion.
The civil is the one that you can hold him until he complies with the order.
Now, this is where she's trying to educate the judge on what's the difference between the civil and the criminal and the way he can apply his punishment.
Just the case law on that is right.
You're going to have to leave on this note for a second, I think, and come back. You don't even know what you're doing, Judge. You about to lose your job. We almost getting to the end, y'all. Thank y'all for your patience. Thank you for tuning in with Grace Levi. This is something that I like, obviously. Y'all see, this is what I like. Oh my God. It's not what I like, it's what I do. It's like watching a football game. But if y'all ever in court, y'all going to need to know how to fight. And watching these trials and watching how these crooked government works is going to equip you, because we're going to have to flip this system over. We got a big fight, y'all. This is not correct. This is not great procedures. This is not the way a judge is supposed to act. This is terribleness. The prosecutor, snakes. This is terrible.
The superseded bond requirement does not apply in the contempt in the presence of the court during the progress of a proceeding OCGA 5-6-13 bond. So you don't get a supersedious on that. On this, on a criminal
he said no
contempt.
no bond for Steele, just like his client.
So just to clarify, it's your ruling that this is a criminal contempt that Mr. Steele has committed, not a civil indirect contempt.
That's correct.
The judge.
Look at her. Look at Miss Love. You ugly. You a special type of ugly, Miss Love. Y'all saw that face? Damn, it caught me off guard. Oh.
2009 Court of Appeals case.
Shit.
6 lays out the distinction, as does the Ramirez case.
There's a case that in fact is, I do you one better, sir. In fact, there is a recent pronouncement out of our appellate courts.
I think I'm addressing a slightly different point of law.
This judge hard-headed. He hard-headed.
This year, it covers the differences between the types of contempt. And then there's another case that I'd invite your attention to, and that is Henry Syverson. It's Sybertson, and that is 368 Georgia Appeals, Georgia App, I should say, 865. And that was decided
Look, Mr. Still texting his family like, listen, I'm not coming home. She's about to go down. Let's just get ready for this.
Point two things out. The statute that you were citing about the supersedious, it only says it's not mandatory. You still have discretion to grant him a supersedious bond.
Thank you.
The other, and so you definitely have the discretion to grant him a supersedious bond. The other issue is if it is a criminal contempt and you are finding him guilty of criminal contempt, then we have to have a sentence imposed. Now, civil is where you get to hold him until he complies. Criminal is where you get to impose a sentence, maximum 20 days and $1,000 fine. So if you're going to incarcerate him under a criminal contempt, he's got to be sentenced.
Well, his contempt is as long as he, when he tells me what the basis of the conversation was, who, I didn't ask what, but he tells me that, then I can certainly, he purges himself of the contempt.
The who is going to lead to the what. Please, Judge, stop it. You're not going to stop with who said it. You're going to want to know everything, and you're going to try to go after that person. So please stop.
That's civil.
That's civil contempt.
That's civil.
Respectfully, I would want you to, in Ray Hughes, which stands for the same point of law, civil contempt imposes punishment as a means of coercing future compliance with the prior order of the court. Here, the prior order of the court presumably is that you have directed Mr. Steele to answer the question, to disclose the information as to who is his source for knowledge of this ex parte meeting that occurred earlier today. Criminal contempt imposes unconditional punishment to punish the act which has occurred in the past and cannot be purged. It is not capable of being purged. In which case, what Ms. Merchant said applies, which is that there is a 20-day maximum sentence and $1,000 fine.
So what he's saying, in my opinion, is that Still should not be charged with a criminal offense. He should be charged with a civil. But because the judge want to penalize him to the max, he's trying to do it criminal. This is going to be a problem because Still has to fight this. He's a lawyer. He cannot have criminal proceedings against him. The Georgia Department, the Georgia GA Department of Criminal Defense Lawyers, they're gonna come kick ass. And I bet you a lot of them are Republicans. They're gonna come and kick ass. Keep on playing. Y'all gonna see what's gonna happen. Because this right here, and then Trump possibly getting into the office, I don't know what's gonna happen. It's gonna be chaos, the new election. The new year.
Is, for all intents and purposes, a misdemeanor offense, Judge.
Thank you.
Which is why the enhanced due process protections apply to that. Now, Mr. Steele has indicated to us he does not believe that he can answer the question without violating his duty of loyalty and duty of confidentiality to his client. So he is being placed in a position where he's either going to jail or he's going to commit an offense that will put his license to practice law at risk. And that is an untenable position to be in. And Mr. Steele is a zealous advocate for his client, and he is simply trying to protect that duty of loyalty and duty of confidentiality, because if he answers your question, it is very reasonable to assume and likely that he will be facing a bar complaint that could result in a suspension or in loss of his license. And so he's in a very, very difficult position where if we were able to have a full contested hearing with the benefit of witnesses and an impartial judge where you're a witness, then everybody can present their side.
You're going to be a witness regardless, sir. You're going to be a witness regardless, sir. What's going to happen is that the judge is going to be so confused. His ass is going to have to take another 15 minutes, and that's where I fast forward to, and come back with his decision, in which this guy is so stubborn and he knows he's wrong. Watch what happens.
The reason being is because that takes away the whole point of criminal contempt, and that is you do something, the court tells you to do something, order of the court, and you don't follow it. I didn't ask him to do anything illegal, immoral, unethical.
It is. It is.
I know what the
against his client. It's immoral.
The privilege is the conversation. I didn't ask him about that. I wanted to ask him about who the person
And
Because I'm sorry.
Mr. Steele has indicated to us that he does not believe he can answer that question without also violating the privilege.
And Judge, that's why we're trying to figure out if it's criminal versus civil. So the issue is you're picking and choosing. You're saying, well, you get the bad side of criminal and no bond, but I really am actually trying to punish you civilly, which is when you hold someone until they comply.
Okay, let me think about it.
Look, I gotta get it together. I gotta get it together.
Okay, all right.
That's where I fast forward. This is where I fast forward a little bit because he got to take time off. This fool, he ain't know what he was doing. I said it, a whole fool, and it's them coming back. About 15-minute break again. That other one was 2 hours. That's why the witness was like this, sleep.
Mr. Steele, if I could ask you to take the podium, please, as well.
Now, this is the best part, y'all. This to show y'all that Mr. Steele is the rawest. Mr. Steele is the bestest. Ride or die, Mr. Steele.
Okay, Ms. Merchant, Mr. Steele, and I apologize.
Mr. Susar.
One more time?
Susar.
Spell your last name for us?
SUSOR. Sierra Uniform Sierra.
Trying to fix my face, y'all.
Good man. Good man. Okay, all right. Okay. All right. Thank you, sir. Okay, Mr. Susar as well. All right, counsel, I've made a clarification to the order of contempt. Mr. Steele, I am going to hold you still hold you in summary criminal contempt pursuant to OCJ 15-1-3, subpart 3, for your failure to comply with my earlier order today. I'm going to order that you be taken into custody and incarcerated at Fulton County Jail for no more than 20 days for this contempt. Those 20 days consisting of every weekend for the next 10 weekends. And you'll be reporting to 901 Wright Street Northwest, Atlanta, Georgia, 30318. At 7 p.m. on Fridays. You'll be released on 7 p.m. on Sundays. And this is commenced this Friday, June the 14th at 7 p.m. and not to end until Sunday, August the 18th at 2024, 7 p.m. subject to further order of this court. And that will be entered and e-filed. You may take whatever steps you and your counsel deem appropriate after that. Okay?
Now look at this. Wait a minute. Wait a minute, y'all.
Yeah, but for whatever reason that doesn't take.
Wait, I'm gonna let y'all watch this.
Then I'd ask that I can be with Mr. Williams and we work on our case all weekend for all those weekends. Otherwise, I can't prepare.
I wish I had this sound effect.
That's up to you, and sir, I will. Sir, if that comes to pass,
You know what sound effect I wish I had? Ride or die. Mr. Steele said, if I'm about to do time in jail every weekend for 20 days, I want to be next to my client so we could go through our trial, because there's no way that I'm going to be able to prepare. Not only is this an interference in YSL having a fair trial and being able for his lawyer to actually prepare for every single week and all of this drama, he's putting him in Rice Street. Okay? We're going to show you what Rice Street is. We're going to do a flashback. Rice Street is the same prison that I've been complaining about all this time. Let's just finish listening for a little while I get these pictures up of Rice Street.
you have my support. I will talk with our sheriff and we may be able to make that work. Okay, if that should occur. Okay. All right.
All right.
Okay. All right.
Let's stop right here. Oh, I'm done. So what I'm going to do is just chop this up a little bit, this whole 1 hour video that we just went over, so y'all can get the keys without my mouth going in, talking about certain aspects. Y'all get the full blunt of what happened today. Okay. Now, what I want to do now is show you guys Rice Street. If y'all don't remember, this is the same place that I've been complaining about on all my lives when I talk about Fulton County and this horrendous, funky, disgusting jail. Let's just look at the Google research. We don't even have to go in on Pacifics. Hold on. Look at this. put more of it on the screen. Let me be small on the screen. Let's start from the beginning. Fulton County Jail inmate beats guards and after ignoring whatever. We just reading some of this stuff. Fulton County Jail tour show. It's this. What is this? Deterioration. I do apologize. Deterioration. This is where they're gonna be putting Still in this horrendous prison. In this, a drone, 2 guns, and $4,500 seized in Fulton County Jail. Contraband investigated, 6 arrests, sheriffs involved. This was January 2024. All right, we're gonna pull up some more. We could get in when it gets into Fulton County because I've been shown what's going on in Fulton County, and they're gonna put Mr. Still in Fulton County a little bit more. Here we go. Fulton County Jail population is now decreased, allegedly. The sheriff. This was October 2023, where they were trying to decrease the population because of the dangerous prison condition. Violent attack in Fulton County Jail, caught on camera. We're gonna put that up there, but I just want to put up the conditions. Let me just put one of the conditions so y'all can see how this is. And then I'm gonna put some links of the videos that I did. Exclusive inside look into Rice Jail, Rice Street. Let's put this up because
one bum ass nigga.
What is this?
Now he needs you and he crying.
You just out the day, bro. Hey, we all can't talk at the same time.
Now I don't even think y'all want to see that right there. Y'all see that right there? Well, look, y'all watching this? This is playing. Hold on, y'all. I think it stopped. Hold on. Oh, 2 things. I'm sorry. I had the other thing playing. It was both for the same channel. I don't want to do this channel. I want to do like a news report. That's somebody's personal channel. I want to go into after the arrest of 2. Let me put it in jail conditions. Okay. All right. The deplorable conditions, and this is where we're gonna get off at. I just want to show y'all where they about to put my favorite lawyer at. What y'all doing with me? Come on. I think I have a lot of things up right now, so it's giving me a little issue. Don't worry, I'll get it. Thank you guys for being with me. I'm going on 3 hours live, so I think my internet's starting to act up. All right, let's do this. This is gonna be the last part. All right, what happened? Can y'all hear me? I know y'all can hear me, but y'all just can't see me. There we go. I'm back on the screen. Something happened, y'all. This is gonna be the last clip. I do apologize. Something happened in like 3 hours. It's like getting on 3 hours mark. That's enough. Let's just put this up of the deplorable conditions that's in Fulton County and where they're putting my favorite guy. He's gonna be right up in there with Young Thug preparing for his case. Let's show you what Fulton County Jail on Rice Street has to.
What former President Trump and the other election defendants experienced at the Fulton County Jail is altogether different from a typical arrest. Even when individuals turn themselves in as they did, they often have to stay overnight. We have reported extensively about everyday jail conditions, and a family member of one inmate spoke to Fox 5's Morse Diggs. Morse is live in Northeast Atlanta tonight with that part of the story. Morse?
Well, Fulton County has gotten some unwanted attention, with national commentators now calling the large Atlanta jail one of the worst in the country. Well, I spoke to a parent of an inmate who is not going to disagree with that assessment. There is one thing the former president has in common with the 3,500 or so inmates on the floors Thursday at the Fulton jail. Aside from that common mugshot, life is starkly different for the everyday arrestee.
I'm not inside, but what I can hear has got worse.
A parent of an inmate incarcerated for a lengthy period said conditions are worse in 2023.
More stabbings, more beatings, more stealing everything they got.
Fox 5 has shown disturbing videos of violence. This scene not connected to the most recent parent to come forward. Aside from the extreme incidents, more mundane issues diminish what the parent calls a level of humanity that should be present.
They give them one jumpsuit to wear, and if somebody steals their jumpsuit, they have to do without for days. My son says it's disgusting. They're butt naked.
Inspectors from Washington have been at the jail.
They pressure washed all the bathrooms and the floors and all that stuff. They turned the hot water on, and they had hot water in there for that one day. And then they turned it back off.
He says the biggest factor is control. Gang members appear to have it on most floors.
Make them give them $15 to $30 a week to buy what they want to. The level of worry is really off the charts now, because every minute of every day you're worried if he's still alive or not.
Now, as far as the deputies, this parent tells me that some of them are conscientious, are very good, but he says the good ones, they leave.
Yeah, and that's what's going on in Fulton County Jail right now. We're about to log off. We've been on for 2 hours and 34 minutes. That's a good number for me. Michael Williams, salute to you. I know you got to be from Atlanta out here if you know about, or maybe you follow the YSL trial. But Gainesville, Judge Gainesville, yeah, he's crooked. And I really think that he's about to lose his job. Chris Hepp, is the judge in trouble? I think he soon should be in trouble. And once this hit the appeal, after all of this money being spent by Fulton County on this damn trial, in this drama, in this political drama, we're going to see what happens to him. But for right now, we're going to put a reminder up there for Judge Gene. What is it? I call him Gene. Glendale, this is for you, baby. All day, every day.
Why are you detaining me? You about to lose your job. You about to lose your job. Get this dance. You about to lose your job because you are detaining me for nothing. You about to lose your job. You about to lose your job. Get this dance. You about to lose your job. I'm Martinez. You about to lose your job. Get this dance. You about to lose your job. Get this dance. You about to lose your job because you are detaining me for nothing. You about to lose your job. Get this dance. You about to lose your job. Get this dance. You about to lose your job because you are detaining me for nothing. You about to lose your job. Get this dance. You about to lose your job. Get this dance. You about to lose your job. Get this dance. You about to lose your J-O-B. You about to lose your job. Get this dance. You about to lose your job. Get this dance. You about to lose your job.
I'm Martinez. Yes, you boy.
Is this shit?
Let's go.
Yeah, hatred and envy, don't let it tempt me. I move defensive. Evil offends me, I yell repentance. We come from trenches. I'm in the secret place of the Most High, you can't offend me. Hamashiach built many mansions, that's where my rent be. Father, help me overcome. People who I used to look up to, they turning foes for none. Father, you my strength and you my courage. I feel bold for some. I wanna feel your spirit on my body like it's clothes or something. Put my vision in your one direction like it's froze or something. I can feel the hatred in their heart is like I owe them some. Yeah, they full of nerves like my hands or my toes or something. No nervous system, but you know I feel it like I'm holding some. Stay in my lane. Anyway, I spin it like I bowl or something. As if I need them for my elevation, like they rope or something.
Anyways, I'm too high up your spirit like I'm rolling, son. Son of the most, I pay my dues forever, owe you one. Yeah. If it wasn't for your presence, I would have no peace, believe it. See, that Bible is my weapon, I don't have no beef, I'm vegan. Yeah, your highness, you a blessing, you a masterpiece, I mean it. And I'm fighting for your presence, full of passion, cause I need it. Father, will we
I
make
could not
it
be here
in?
breathing and be comfortable if I was really as bad as they was making it. You know, nobody could be around me. So for me to be this calm, I must have some kind of inner peace. And my inner peace is knowing that once everybody take the time to really see what type of person I am, you'd be surprised that I stuck around this long. I have to make the life that I do live as happy as I can and try to do the best with what I have. You know, live the best life I can live, be as happy as I can be. Nothing is perfect for anybody. I don't.
Boys, I swear, I think I figured it out. You know why they don't want us redneck brothers and sisters and the hood brothers and sisters getting along? You know why? Because we'd be unstoppable. I'm telling you right now, we would shut shit down.
The real estate market often seems like a distant world where only an elite of experts is successful. In a time of so much uncertainty in the air and bad news, realist investing can seem intimidating. But today, I want to tell you that if you make the right decision today, you can enter the real estate market from the back door. Bad credit record? No credit at all. Do you dread the idea of having a home loan? Do you dream of owning investment properties? You are in the right place and right time, because we have created a program which is a tax lien and deed investment online course of only 14 hours. This course is specially designed for people like you who have big dreams. You will learn at your own pace and everything from your home computer. This is your chance. Join our membership for $19.99 a year. What are you waiting for? Visit our website primetimehomebuyerBuyback.org and sign up today for course access.